Hey guys, come on in. Come on in. Don't all run at once. We are going to be reading a recent opinion. It came down yesterday, June 18th, on the case of Hunter v. United States. This is originally a case stemming from the Fifth Circuit, and it deals with the waivers, the appeal waivers that are attached to a plea bargain. So typically there's going to be a term when you take a plea deal where you waive your right to appeal your conviction and to appeal your sentence. We're going to get into the background of the specific set of facts in the case for Munson Hunter. We're going to look at what the Supreme Court decided, and we're going to focus in on a concurring opinion written by Justice Neil Gorsuch, which maybe it'll surprise you, maybe it won't, but I think he absolutely cooks. He's going to take us through a history of how plea bargains kind of evolved through the criminal justice system over the last 2 centuries, and the state of plea bargains, plea deals today, how they're used like an enormous amount of the time, and the problems he sees with that. And he, along with those who join in his opinion, say, look, today's decision is just a start, but we need to do more work. And this is, quite frankly, it's going to be a pretty narrow holding. So real quick, an agreement not to appeal a sentence is unenforceable. So that's the appeal waiver. They're finding that such an appeal waiver is unenforceable when it would result in a miscarriage of justice. It's a very high bar. They explain here that that means when it would leave in place the kind of egregious error, high bar, that would bring the judicial system into disrepute. So what we're going to read again isn't like everybody ever can suddenly appeal their conviction or sentence that was the result of a plea deal, but I think it's still a really important holding anyway. So let's get into it. The way we're going to do this stream is we're going to start with just to get the background context, we're going to start with this little, when the SCOTUS agrees to hear a case, they grant the petition for writ of certiorari. They're like, hey, these are the questions we're going to accept from this case. And there's a quick little summary of what we're going to talk about. That's where we're going to start. We're going to look at the opinion that came out yesterday. And then if you guys are interested, I've got the oral arguments queued up. We can run it back to those as well. So as you come in, let me know. Let me know if you followed a case that had a plea deal at issue. And drop that in the chat, drop that in the comments. I think plea deals are very, very common. Sometimes they're rejected, but the plea negotiations are still interesting. And a lot of other times, the case you might be following ends with a plea deal being accepted. So let's get into it, you guys. Hope everyone's having a good day. Hit that like button. We've got Hunter v. United States here. The question presented, they say this court has recognized that, quote, no appeal waiver serves as an absolute bar to all appellate claims. So there's already been certain protections in place, such as if your sentence resulting from a plea deal, when you are sentenced, if your sentence is a nullity, if it's void as a matter of law, it's an illegal sentence based on statute, you can appeal that and say, hey, look, that's wrong. This should be, this isn't right, even if you've waived your right to appeal. Now, a recent example of that would be the Fit Lawyer ATL and Jim, Happily Angry Lawyer. They pointed out that Antonio Sledge had an illegal sentence in the YSL trial. And they pointed that out to the court. The court corrected it. And there's still some ongoing issues with that plea deal, but that was one of them. So those protections do exist, right? Those have been there, as long as somebody points them out and brings it to the court's attention. Here, what are we talking about? In the decision below, the Fifth Circuit affirmed its precedent. Oh, wait, I missed one. But the court has made no statement on what particular exceptions to appeal waivers may be required. So besides the things that would just be an illegal sentence, what else? What else could get us to a level where, even though somebody waived their right to an appeal, we should warrant an appeal? In the decision below, the Fifth Circuit reaffirmed its precedent, holding that there are only 2 grounds on which the defendant who signs a general appeal waiver may challenge their sentence on appeal. So first is a claim of ineffective assistance of counsel. So if you're like, look, maybe I took this plea deal, but my attorney really messed up in how they advised me on this. That's one avenue. 2, claims that the sentence exceeds a statutory maximum. So that would be just like the example with Antonio Sledge in the YSL case. Then the 6th, 10th, and 11th circuits adopt a similarly narrow view of the exceptions to general appeal waivers. In stark conflict, so we have an extreme differentiator here. The 1st, 2nd, 4th, and 9th circuits permit defendants who sign general appeal waivers to raise a broad range of constitutional challenges to their sentences beyond the limited exceptions recognized by the 5th Circuit and the other courts on its side of the circuit split. The 5th Circuit below, and that's where the Hunter case comes from, also reaffirmed its precedent holding that an appeal waiver applies even when the sentencing judge advises the defendant that he has a right to appeal and the government does not object to that advice. Although other circuits agree with the 5th Circuit, the 9th Circuit squarely holds otherwise, releasing defendants from appeal waivers in identical circumstances. So the questions presented that they were going to hear here are: 1, whether the only permissible exceptions to a general appeal waiver are for claims of the ineffective assistance of counsel or a sentence that exceeds the statutory maximum. Or 2, the second question, whether an appeal waiver applies when the sentencing judge advises the defendant that you have the right to appeal and the government fails to object. So let's get into what happened with Munson Hunter. We're going to go right to the opinion. They're going to summarize the backstory here for us and do it better than I would off the top. All right, and again, this just came down yesterday. They are still in this court term. They still have some cases that are undecided. We're still waiting on a decision if you guys are following the Chatry case. That is the geofencing. Was that a violation of somebody's rights against search and seizure? Not just the defendant himself, but the individuals who were in the geofence location whose devices also came up and may have been searched as a result of this geofence looking for a suspect. So we're still waiting on that. They have a couple cases left to decide this term, but they rolled out some big decisions yesterday. So we've got petitioner Munson Hunter III was charged with 10 counts of bank and wire fraud for a years-long scheme costing various financial institutes about $500,000, right? So that's the no-no. That's the big bad thing that's going on here. He entered into a written plea agreement with the government under which he pleaded guilty to 1 count of aiding and abetting wire fraud in exchange for dismissal of the remaining 9 charges and a promise not to prosecute him for the described conduct in the future. The agreement included an appeal waiver under which Hunter waived the right to appeal his conviction and sentence, except he did not waive the right to raise a claim of ineffective assistance of counsel. The agreement further provided that any modification of its terms must be in writing and signed by all parties. The district court accepted the plea after deeming it knowing and voluntary. And that's pretty much the standard that you'll hear. If you've ever watched a plea colloquy or someone try to argue their plea, well, Your Honor, it was knowing and voluntary. And then the prosecutor will ask, and you sign off that it's knowing and voluntary. The judge is supposed to confirm that you're not under the influence when you're signing off on this and that you understand. That's pretty much the standard. Knowing and voluntary. And so they say it's sentencing here. The probation office, they'll call the probation office up and then get their recommendations. Probation office recommends that as a condition of supervised release, Hunter be required to participate in a mental health treatment program and take all mental health medications prescribed by his treating physician. Hunter objects to this. They're like, look, we don't want to do the medication, the mandatory medication part. The district court tells Hunter that if the treatment provider prescribes drugs, you should take them, while also telling Hunter that he could address any future dispute about medication to the probation officer, or, if needed, to me, which this is kind of hinting that maybe it's not mandatory, it's not fixed. The district court then imposed a sentence of 51 months in prison, followed by 3 years of supervised release, including the contested medication condition. At the close of the hearing, the court told Hunter, all right, you have a right to appeal. If you wish to appeal, your trial counsel will continue to represent you. When asked if either party wished to say anything else, Hunter's lawyer said, nothing from the defense, and the prosecutor replied, Your Honor, I believe, no. Hunter appealed, challenging the mandatory medication condition as infringing on his fundamental due process liberty interest in being free of unwanted mental health medication. The government sought dismissal based on the appeal waiver. Hunter acknowledged he had knowingly and voluntarily signed the waiver, but argued that an appeal waiver is unenforceable when the disputed aspect of a sentence violates a fundamental constitutional right. And alternatively, that the district court's statement at sentencing about appeal rights, along with the prosecutor's failure to object, voided the waiver. Right? So court says you can appeal, and nobody objected. The Court of Appeals for the Fifth Circuit dismissed the appeal, holding that the district court's misstatement did not impact the validity of the appeal waiver, and that under circuit precedent, the general rule that appeal waivers are enforceable has only two exceptions: when the waiver was tainted by ineffective assistance of counsel, and when the sentence exceeded the statutory maximum. And because neither exception applied, the Fifth Circuit held that Hunter's appeal could not go forward. All right, so that's their syllabus. That's their intro on the case and what happened. All right, so we've got, forgot to get you guys up here. Hope you guys are doing well. Get the chat going. Chat away. Don't be mean in the comments. That's like the rule here. No personal attacks. But other than that, share your thoughts. Share whatever you're thinking about. Good to see everybody coming in. BMAC, thank you for being a member 20 months. Saying good morning, Kat. Love your content. Love you back, BMAC. We have, that's so nice. Word Matter says, hello, friends. Hello, hello. Ooh La La, one of the best names, says, I'm super interested in this. Thanks for covering. We've got mentions of cases. Hewerman, Koberger. YSL is a huge one. Well, I mean, YSL had like close to a dozen plea deals baked into it. I know, I think over 12. Because of the second set of co-defendants that were supposed to go to trial ended up resolving with pleas too. So yeah, the YSL trial has like multiple examples of plea deals. Oh my goodness. Mel Klum, thank you for the sticker. Love your dog. Very cute dog, good looking dog. And also, yes, free Muktunk. A whole mess. There's like multiple issues. And Jim and Tiffany have done such great work articulating the issues and the improper procedure through which that plea deal for Muktunk was prepared and enforced, and how the sentencing worked. Just a whole mess. So if you want to like do a micro case study, I highly recommend. Tiffany's joined, but she hasn't really done too many streams on her own channel. Happily Angry Lawyer, go to his channel. He's got the whole breakdown on some of the Muktunk stuff. And I forget the court term deadline. That's a Georgia case. And I think Jim said like first week of July is when the calendar term ends, where they should have a decision on their most recent efforts in Antonio Sledge / Muntunk's case. Ulala says, what about people who make a plea deal, waiving the appeal, and prosecutorial or law enforcement corruption or crimes are subsequently uncovered? Sometimes that's deemed waived. And, you know, there are some states that are passing legislation that allows for some relief. A recent example I can think of, and I don't know the specifics, I don't know like the gray areas, what's in the clear for you to bring a grievance forward or what's not, but I know Tennessee has recently in the last few years brought something forward where even if you take an Alford plea, where typically you can maintain your innocence, you still previously were waiving any right to appeal. Even though you're maintaining your innocence, you can maintain your innocence under an Alford plea. That's the purpose. You couldn't bring forth a grievance trying to change that later. You waived all of your appeals regardless. And now they've changed a little bit. I don't know what the practical effect is going to be, but there is now a pathway. It might not be the most paved pathway for someone who took such a plea to continue to fight their innocence claims and maybe get rid of their conviction. So that was Tennessee that I recently heard about that, and really within the context of Dylan Adams in relation to the Holly Bobo case. So if you're interested in that, that's probably one to put on your radar, and I would point to the Trial and Error podcast for information on updates on that. Of course, I'll cover it too, but I think they're like the primary source there, as one of their co-hosts is stepping away from the podcast to help with Dylan Adams' case. So also, don't forget to hit that like button. Good reminder. Thank you, BMAC. Hey, Pashan. Hey, Linda. And thank you for sharing Happily Angry Lawyers. Link is in the chat shared by Factual Lie. So let's continue here. They're holding here what they're ultimately going to determine. We saw a preview on the little like cheat sheet is that an agreement not to appeal a sentence is unenforceable when it would result in a miscarriage of justice, meaning when it would leave in place the kind of egregious error that would bring the judicial system into disrepute. So A, the district court's misstatement at sentencing. They're saying that this was a problem, right? The district court's like, eh. But what do they say? The district court's misstatement at sentencing and the government's silence did not negate Hunter's knowing and voluntary appeal waiver. So remember when I said this is going to be narrow? They're like, nope, doesn't matter that he was told he can appeal. Doesn't matter. Doesn't matter. Doesn't matter that the state didn't object. Doesn't matter. It was still knowing and voluntary. So again, it's a very narrow holding, I think. The plea agreement specified that any modification of its terms must be in writing and signed by all parties. So they're relying on the written language, even though whatever the court said and the silence of the state would have occurred after any signature or agreement on this paper. It still remains binding. And personally, I think that's kind of like, when I think of how contracts work, sure, maybe you want to like get something new in writing. But in the context of a judge saying something on the record, I feel like that should be a little bit more binding. And Carrie, you should have some deference for that compared to someone saying something verbally after signing a written contract with you, where you probably should make sure you get the updates in writing, sign off on it, initial it, whatever. But what about when it's a judge saying something? Seems like it should be more significant. Just that's my common sense chiming in. But here they don't agree. They don't agree with what I would think should be the way. They say, nope, 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 nope. Then we've got, and even assuming away that provision, nothing that happened in the sentencing hearing shows the mutual agreement between the parties needed to accomplish a modification. So because the two parties aren't verbally explicitly agreeing to get rid of that waiver, whatever the judge says, and whatever the state fails to say to counteract what the judge says, can't undo, it can't become something that changes the agreement between the two parties. And those parties are, of course, the prosecution team and the defendant who's taking the plea deal. The court's statement about appeal rights could not change the parties' agreement because it is the parties' intent that matters, and their non-response falls far short of showing agreement to alter a conflicting term. The government did not waive or forfeit its right to enforce the appeal waiver by failing to correct the court's misstatement. Under ordinary litigation principles, waiver requires some affirmative signal of abandonment, and staying silent, as here, not picking a fight, does not qualify. Forfeiture generally does happen through silence because it is the failure to make the timely assertion of a right, but the proper time for the government to assert its right to enforce an appeal waiver is after a defendant files a notice of appeal, and not at sentencing. The decision that Hunter's appeal waiver remains valid matches one that the court reached in a nearly mirror image case, Class v. United States, and they give the citation here. So we've got, the question becomes whether the government's right to enforce an appeal waiver has limits, and if so, what they are. So, right, we're moving on. This isn't going to work. We're getting rid of the option 1 here. But what about if something absurd is going on? What about something crazy? They say, if it is common, it's a common ground that an appeal waiver must be knowing and voluntary to be valid and thus to be enforceable, and that an appeal waiver is not knowing and voluntary if it was the product of ineffective assistance of counsel. Putting that to the side, the Fifth Circuit holds appeal waivers unenforceable only when the sentence exceeds the statutory maximum. The government maintains that knowing and voluntary appeal waivers are always enforceable. But most courts of appeals have instead taken a less stringent approach, declining to enforce appeal waivers when doing so would produce a quote-unquote miscarriage of justice. So the question for the court is, which position is right? The answer stems from the special and indeed pivotal role of the judiciary in approving and implementing appeal waivers. A district court must accept the plea agreement, including any appeal waiver, before it can go into effect, and that decision is given over to sound judicial discretion. An appeal waiver then falls into the lap of the Court of Appeals, which has exclusive control over its operation. The real-world effect of a waiver turns only on whether the appeals court decides to enforce it, and enforcement will cement into place a district court sentence whether or not lawful. Because that is so, the standard for enforcing appeal waivers implicates the interests not only of the plea agreement's parties, but also of the judiciary. If a court always enforces appeal waivers regardless of the kind of degree of error tainting a sentence, the judicial system's integrity may come into question. So this is the court here saying, like, look, we need to set a standard, and that's a horrible bracket. We need to set a standard. Because someone could just, a judiciary could just unilaterally always deny appeal waivers, even when there would be a miscarriage of justice. And we've already seen the holding, so we know that the standard they're going to set is like, look, we want to limit like the most absurd things. But for the most part, you can almost unilaterally uphold the convictions and sentences that stem from appeals and say that the plea deals, and that any right to appeal has been waived. So they say the court has recognized when addressing waivers of other rights held by criminal defendants that federal courts have an independent institutional interest in ensuring that legal proceedings appear fair to all who observe them. And that's from Wheat v. United States. And that some rules may be so fundamental that they could not be waived without irreparably discrediting the federal courts. In this case, Mezzanato, I think they cite a lot in this opinion, or at least reference back to, as well as in the oral arguments. So we're probably going to hear about Mezzanato a few times. Whatever the parties have agreed to, the court's own responsibility when enforcing a waiver is apparent, and so automatic enforcement may risk institutional harm. So again, it can't be 100%. It can't just be unilateral all the time. It can be almost unilateral. But we've got to protect against certain absurd circumstances. Accordingly, neither the government nor the Fifth Circuit's proposed rule can be the right one. The government's position first runs into the scenario that even the Fifth Circuit will not tolerate, when a judge imposes a sentence beyond what the statute allows. Suppose a judge sentences a misdemeanant. I've actually never seen that word spelled out that way. So someone who is convicted of a misdemeanor is a misdemeanant to life in prison. When the applicable law caps a prison term at 1 year, if an appellate court had to dismiss the resulting appeal, it would call into doubt the judicial system's very attachment to law. But so too would a dismissal in certain other situations, which fall outside both the government's and the Fifth Circuit's rules. So for example, if the sentencing judge, are we going to get into the orangutan stuff? I don't know if you guys have seen that. It's going to be a lot of references to orangutans. Maybe not in all the stuff that we read. We'll at least see it one time. But they keep going back to this reference of like, well, can somebody waive their right to a jury trial if they're meant to go forward with a jury of 12 orangutans? That would be absurd. And that's an example they keep fixing back to. So they say unconstitutionally considered race or religion impose a condition that a defendant not become pregnant, right? So kind of absurd, requiring someone not to become pregnant as a sentencing condition. Or let an orangutan pick a sentence out of a hat, because that would be absurd. That would be absurd. However, certain the parties' agreement, the courts are too enmeshed in its approval and implementation to escape responsibility for such results. The court thus approves the majority view among the courts of appeals that an appeal waiver is unenforceable when it would result in a miscarriage of justice, such as requiring that a defendant not become pregnant or let an orangutan pick a sentence out of a hat. The miscarriage of justice standard sets a high bar. The waiver may be set aside only if the sentence is marred by the kind of egregious error that would bring the judicial system into disrepute. The error must be obvious, not one a judge could reasonably make, and must be of the type that would undermine public confidence in the judiciary. Standard fair errors in misapplying sentencing law cannot cancel an appeal waiver. But a high bar is not the same as an insurmountable one. The miscarriage of justice limit, as many appellate courts have properly applied it, offers a safety valve for extreme cases when the justice system's basic integrity is at stake. We're going to read a little more of this, and then we're going to jump to some of the meatier parts of the opinion. The nature of the miscarriage of justice limit precludes any attempt to list all the situations in which it will overcome an appeal waiver, but a few examples of the kinds of errors that would bring the judiciary into disrepute may provide guidance to lower courts, such as a sentence exceeding what the relevant statute allows, a sentence infected with a blatant constitutional error, such as when a judge takes account of a constitutionally impermissible factor, like race, in deciding a sentence, or imposes a constitutionally infirm condition of supervised release, and a sentence imposed without some minimum of civilized procedure. These examples are just examples, not intended to be exclusive, but they serve to illustrate the high bar a defendant must surmount to overcome an appeal waiver. The court doubts that this confined exception will open the floodgates to waived appeals. Many circuits already apply a miscarriage of justice limit, and the government has offered no evidence those courts are awash with appeals. The circuits using this approach have understood it to erect a substantial barrier, and such a hard-to-meet standard presumably deters many appeals, while those still filed can often be quickly dismissed because the errors asserted are uncertain or ordinary. The court declines to decide in the first instance whether Hunter's challenge to the mandatory medication condition satisfies the miscarriage of justice standard. The Court of Appeals did not address the question, and this court is a court of review, not a first view. So this is why they're going to send it back. They're going to remand this decision. They're going to send it back to the Fifth Circuit to decide. So they say it's therefore up to the Fifth Circuit to decide whether enforcing Hunter's appeal waiver would result in a miscarriage of justice. All right, so quick, it was vacated and remanded, going back to the Fifth Circuit. Kagan's doing the opinion of the court. We have two concurrences. So we have pretty much everybody but Thomas joined in on this. It was 8-1. We had Gorsuch file a concurring opinion, which this is pretty much going to be the bulk of what we look at today. It gives a great history of the evolution of plea deals and the way that they began to be used in large volume in our criminal justice system, and the concerns that brings in modern times. And really, Gorsuch advocates that, I know this particular case, the questions before us aren't about these other changes that we should consider in relation to how plea deals are used, but I think we should consider them, and this case is just the start. His opinion was joined in by Sotomayor and Jackson, and then Kavanaugh also filed a concurring opinion in which Alito and Barrett joined. And then Barrett filed her own concurring opinion. So they're all trying to agree a little bit in these overlapping ways. And then Thomas dissents. All right, so we'll read a little bit of Justice Kagan because she is the majority opinion writer here, and then we'll jump to the concurring because I think it's super interesting. It's super informative. So here we have plea agreements between a criminal defendant and the government often include an appeal waiver, a promise by the defendant not to appeal his conviction or eventual sentence. In this case, we address a dispute about when such a promise is unenforceable in the sentencing context. We principally hold that an agreement not to appeal a sentence is unenforceable when it would result in a miscarriage of justice, meaning when it would leave in place the kind of egregious error that would bring the judicial system into disrepute. So Hunter entered this written plea agreement with the government after he was charged with the 10 counts of bank and wire fraud for a years-long scheme costing various financial institutions about $500,000. Under that agreement, Hunter would plead guilty to 1 count of aiding and abetting wire fraud, and then in exchange, the government would dismiss the other 9 charges and refrain from prosecuting Hunter in the future for the conduct. So here's the opinion. We've got the agreement also included an appeal waiver, applying to both Hunter's conviction and his still-to-be-decided sentence. Under that provision, Hunter knowingly and voluntary, right? That it's, it's like so rare that I've seen a court find that, hey, this plea deal was actually not knowing and voluntary. It wasn't knowing and voluntarily waived. His conviction and sentence, the right to appeal those, except that he did not waive the right to raise a claim of ineffective assistance of counsel, which has long been a recognized exception. And with specific references to his sentence, Hunter acknowledged his awareness of certain facts, that the sentence had not yet been determined by the district court, that the government made no promises or representation about that sentence, and that the sentence to be imposed was within the sole discretion of the sentencing judge. The plea agreement further specified what would happen if Hunter nonetheless appealed. The government would assert its rights under this agreement and seek specific performance of Hunter's appeal waiver. Finally, the agreement provided that any modification of its terms, including of the appeal waiver, must be in writing and signed by all parties. After the agreement was reached, and we went through some of this history, you're agreeing to this, and then Hunter was asked whether he understood. He says yes. He's asked a few more similar questions and says yes. So the court deems the plea knowing and voluntary, adjudge Hunter guilty of aiding and abetting wire fraud, and scheduled a sentencing hearing. At that sentencing hearing, they call the probation officer up, and the probation officer gets into his medical history. They say he suffers from symptoms of anxiety and depression, he has refused medication to treat his symptoms, and then presents a report. So the report that they proposed suggested this mental health treatment program we heard mentioned earlier, and that he should have to take all of his medications that are prescribed. Hunter objected to that medication part, saying that he shouldn't be forced to medicate, and the judge responded that if the treatment provider prescribes the drugs, you should take them, while also telling Hunter that he could address any future dispute about medication to the probation officer, or if needed, to me. So again, to me, I read that. If you said that to me, you're giving me a pathway out of this mandatory medication. It's not very clear on what that pathway would look like, but you're at least saying it's available. The district court later imposed the sentence and made closing remarks, including a fairly inexplicable one at issue here. So they're like, well, we can't really explain why the court did this. But they say, let's see. They do this medication thing, Hunter objects. Then the court grants the government's motion to dismiss the remaining counts, as they agreed that they would do, confirmed with Hunter's lawyer that the government had complied with the plea agreement, and finally addressed Hunter. So the judge says, all right, you have a right to appeal. If you wish to appeal, your trial counsel will continue to represent you. Then turning back to the lawyers, the court asked whether anyone wished to say anything, and nobody did. The state kind of almost did, but then they're like, never mind. And then that's it. So then Hunter promptly appeals, challenging the mandatory medication condition. Right? So his appeal is narrow. I mean, maybe they're just not saying it, but it's not indicated here that he's trying to appeal his conviction. It's just like, look, this medication condition, this requirement that I take this medication, I objected to it, I don't want it, and I'm appealing that part. That condition, he argued, infringed on his fundamental due process liberty interest in being free of unwanted mental health medication. And so they cite back to the brief, and then the government's like, look, he agreed to this. He knew that the judge could come up with certain terms. It was up to the judge's discretion, and he waived his right to appeal. So, and then let's see. They go through the procedural history where the Fifth Circuit dismisses, and then the Supreme Court grants certiorari. They're going to hear this case, as they did, as we know. And then they say the two questions they're going to hear and announce that we're adopting the miscarriage of justice approach and accordingly remand the case back. So what does Kagan argue here, though? She says they want to pause to address the more case-specific argument Hunter makes for allowing him to appeal. That at his sentencing hearing, the district court said he could, and the government did not object. They're rejecting this. The majority here is rejecting this. If that alone were enough to negate a knowing and voluntary appeal waiver, Hunter could bring his appeal regardless of our resolution of the just described circuit split. But it is not enough. Contrary to Hunter's arguments, the court's remark did not modify the plea agreement, nor did the government's failure to object give up its ability to later enforce the agreement terms. Now, the oral argument deals a lot with this. They're going to talk a lot about contract law and, if another person who they're going to say is the judge here says something, but it's two other parties that got into a written binding agreement, what this third party comes along and says isn't going to change the terms of that agreement unless those two parties explicitly agree to change the terms and modify that agreement. Right? So we're going to defer on reading this because they're going to discuss it a lot in the oral arguments. And the court here disagrees that the judge's statement becomes an oral modification of the written agreement between the defense and the prosecution. I think that's just important to know because a lot of the times that's some of the arguments about appeals will be, look, the judge said something different. That should supersede. He's the judge. She's the judge. They're on the bench. That should override everything. It's their court. It's their rules. But here they're saying this is the Supreme Court of the United States saying, not enough. Nope, not enough to modify the underlying written plea agreement. Let's see. All right, so then they say the question then becomes whether that right to enforce has limits beyond any stated in the agreement itself, and if so, what they are. It's common ground that an appeal waiver, like the rest of a plea agreement, must be knowing and voluntary to be valid and thus to be enforceable. And let's see. Okay, there's a footnote. They cite a case, Brady v. United States, with a footnote that says we do not otherwise address in this opinion the circumstances in which an appeal waiver might be invalidly obtained, as through fraud or coercion. We instead discuss only when a validly obtained waiver may become unenforceable. They say related to that settlement rule is another. An appeal waiver, again like the rest of this agreement, is not knowing and voluntary if it was the product of ineffective assistance of counsel. And the voluntariness of a plea deal depends on whether counsel's advice was within the range of competence demanded of an attorney in criminal cases. And I don't know. I think the saying about ineffective assistance of counsel, the bar for competence is like, as long as you're awake while your client's case is going on, it's fine. You're competent. Not a very high standard to reach. So, not very easy in this context to raise the issue of, hey, I actually didn't voluntarily waive this right to appeal my conviction or my sentence when I took this plea deal because I had an ineffective attorney. They're not competent. Why do you think they're not competent? Well, they didn't really properly advise me. A whole mess. And actually, now that I think about it, I'm going to cover a case soon with Lisa, not with her. It's a case that Lisa Figueroa is currently presiding over, where she came in after a woman took a plea deal at the advice of prior counsel, agreed to like all of these counts, and it was going to give her like a felon status. And she ended up arguing like, look, I didn't know that I was going to get this felon status. I wasn't aware of how this would stack up. My attorney didn't even talk to me. So Lisa Figueroa from Florida Defense Team is her YouTube channel. Great channel. Helps fight for like reconsideration to appeal this plea deal, the conviction and the sentencing. They had a hearing on it and the judge agreed. Bye-bye to that plea agreement. Convictions vacated, sentences vacated, of course, and I believe it's set to go to trial in August. I have to get in touch with with Lisa's son, Justice, see when that case, if it's going to be on time in August, and we're going to cover that case. It was a case where like school parents and teachers are getting into it, and the father might have had more like brusque interactions with the school officers. But the mom, the wife, really didn't. And she was charged with like all these different charges. And it looks really messy from the initial video, but when you slow it down and watch it, I was surprised to see what this woman was charged for, and then to find out she just accepted a plea deal for all of this stuff and didn't really understand it. I'm like, okay, I kind of see why this is a mess. So there are occasions where pleas are voided out, the resulting conviction sentence voided out, they're reversed because of ineffective assistance of counsel. It's extremely rare. Huge win, in my opinion, for Lisa Figueroa. Great advocacy. So if you want to see a case where this actually does happen, there is one. And we're going to talk about it as we approach August. So, and also check out Florida Defense Team. Great channel, great recaps. If you like Bruce Rivers style content with the attorney sitting at the desk, quickly explaining to you the basics of the law being discussed and also the facts of the case, like the overlap of learning the law and a specific case update. She's got that same style. I think you'll love it. And I'm excited to bring it. I forgot about that case. I haven't previewed it to you guys yet, but very relevant to this actual effective and successful argument of an ineffective assistance of counsel claim in relation to a plea. Very excited about that now. All right, let's keep going though. Let's keep going. Let me think also, I saw Autry's fake accent in here. Still one of my favorite usernames. Says, I can't give membership, so it's a super chat this morning. Well, thank you so much. Thanks for hanging out with us also. Big thank you. Always loving you get to hang out with us. Montana Lil is here also. We've also got Christy in the building. Mavka. We got Nola is for livers, not lovers. C major. I was listening to a bunch of like music theory breakdowns, and every time they said C major, I thought of you. Hope you're doing well. Hey, Marcia. Or maybe it's Marcia. I'll have to figure out which one it is. Hey, Granny Debbie. Good morning. Good morning. We've also got, oh, look, we got the Granny gang in here. Guys, Florida passed a law this week, a new bill, expanding the list of available criteria to classify somebody as a gang member. It is easier than ever to be classified as a criminal gang member in the state of Florida. So if we get a third Granny in here, we might be in trouble. Good to see you guys. Hey, History Homicide. Did I get everyone? I think I got everyone. Yeah, but good to see everybody. If I missed you, I promise it is not personal. So we've got putting all that to aside. Like an appeal waiver tainted by ineffective assistance of counsel is not enforceable. And they have a footnote here saying that every circuit, including the Fifth, they're like side-eyeing the Fifth Circuit here through this opinion, has recognized as much. All right, and then they cite a bunch of cases. And they say, in any event, the government appears to include an ineffective assistance exception in all plea agreements it makes, as it did in Hunter's. All right, so they're still putting it in there as a term, even though it's not enforceable. But they're trying. Those prosecutors are trying. They say, putting that to the side, the Fifth Circuit, as noted above, holds appeal waivers unenforceable in only one circumstance, when the sentence sought to be appealed exceeds the statutory maximum. The government here espouses yet a stricter view, maintaining that knowing and voluntary appeal waivers are always enforceable. So here, I think we're just writing to yell at the United States. We're yelling at the government for even trying it. And we're going to hear a little bit of this argued in the oral arguments. The government is still trying to say, hey, we would argue that even these exceptions that you've decided are unenforceable, that there shouldn't be a circuit split. We, the Fifth Circuit, want to decide if it goes above the statutory allowable maximum, too bad, so sad, they waived it. They agreed in this deal. It should be fine. So it seems like this is a finger wag at the Fifth Circuit for even trying to argue that. So they say, but as Hunter notes, most courts of appeals have instead taken a less stringent approach, declining to enforce appeal waivers when doing so would produce a miscarriage of justice. Which position is right? The answer stems from the special and indeed pivotal role of the judiciary in approving and implementing appeal waivers. Such a provision, of course, is part of the bargain struck by the defendant and the prosecutor without judicial involvement. But the district court must accept the plea agreement, including any appeal waiver, before it can go into effect. And that decision is one given over to sound judicial discretion. They cite here Federal Rules of Criminal Procedure, Advisor Committee notes on the 1974 Amendment to Federal Rules of Criminal Procedure. The acceptance or rejection of a plea agreement is left to the discretion of the individual trial judge. If thus approved, an appeal waiver next falls into the lap of the Court of Appeals, which has exclusive control over its operation. And a lot of this is procedural. Nothing, after all, literally prevents a defendant who signs such a waiver from filing an appeal. The court's docket is as open to him as to any other unhappy litigant. So the real-world effect of a waiver provision turns, and turns only, on whether the appeals court decides to enforce it. And all they're saying here is like, look, even if you sign a waiver, people file appeals for things they said they agreed not to appeal all the time. They try it anyway. So ultimately, even though the litigant has some discretion, it doesn't matter. It's going to be the gatekeeper now becomes the Court of Appeals. So the consequence of that decision has everything to do with courts and the judgments they render. If enforced, the appeal waiver will, by eliminating judicial review, cement into place a district court sentence, whether or not lawful. From start to finish, then, the courts are in the middle of, and partly responsible for, appeal waivers and their results. So this is why we find it necessary as a court to at least create this safety valve and make sure the safety valve is there for these absurd circumstances. So if a court always carries out those waivers, no matter the kind of degree or error tainting a sentence, the judicial system's integrity may come into question. This court has explained the point when addressing waivers of other rights held by criminal defendants. And they go into some other cases and other rights. They say so too, in United States v. Mezzanato, we recognize that some evidentiary rules may be so fundamental to a trial's legitimacy that they could not be waived without irreparably discrediting the federal courts. To show the idea's obviousness, we borrowed from a Court of Appeals opinion. If the parties stipulated to a trial by 12 orangutans, I always say orangutans. I had to like practice in my head to not put the G at the end of orangutan. Orangutans. The defendant's conviction would be invalid notwithstanding his consent, because some minimum of civilized procedure is required by community feeling, regardless of what that defendant wants. So, what this is saying is like, chat, say we're watching a trial and the defendant agrees, right? We see in trials all the time, defendant can waive their presence at a hearing, even if it's a critical stage. Can waive right to a jury trial, do a bench trial. All right, you have that right. Maybe we wouldn't do the same thing in that defendant's shoes, but do we think such a decision is just like devoid of justice and we think it's so ludicrous, so absurd? But if we were sitting here as a live chat, about to watch a trial, and we're watching the pretrial hearings, and the defense requests, the defendant's like, I really, really, really want to be tried by 12 orangutans. And like 2 alternate, bring 14, bring in like a pool of orangutans. We're going to do jury selection, bring in like 70. We're going to voir dire these orangutans. We're going to narrow it down to like 12 plus 2 alternates, and we're going to go to trial. This would be way easier in Florida, where often our trials are just juries of 6. And we're sitting here watching this pretrial hearing. We're like, I mean, that's his right, but like, outside of him having his rights, would this trial even be something that we would see legitimate as a legitimate process anymore? So that's why they're using this orangutan example, right? A jury trial is an individual's right. And maybe they can say they concede to do things a certain way. They're fine with it. But at what point does it become something where we look with skepticism at the judicial process because of whatever thing is going on? It becomes absurd. Did you voir dire with the bananas? Montana says add the G back in. Orangutans. It's because of the great branding by that Tang drink. I think that's why. I think the Tang orange powder mix is why my brain thinks there's a G at the word of orangutan. So, good times. DB's like, this is big. We can now do trials with any 12 animals we want. We'll get a panel of 12 sea lions. 12 panels of sea lions. Oh, and SCOTUS, I think, just granted the petition of for writ of certiorari for a case that it's a Florida case that's appealing a different Florida case that previously set the standard precedent that the Constitution doesn't necessarily guarantee a right to a trial by the number 12. And now there's another case challenging that holding, also coming out of Florida, that SCOTUS is going to hear, where this man is challenging, saying that his 6-person jury deprived him of his constitutional right. So we're going to follow that. We're going to talk about that because, I mean, big difference. Would you rather be tried by 6 or 12? I'd want 12. I mean, I guess one way to look at it is maybe it's easier to get 6 to acquit, depending on your circumstances. It would suck to have a mistrial because 11 people want to acquit you, and one loop-de-doop that doesn't even want to participate in deliberations, but the judge won't swap them out, holds it up, and you can't get an acquittal because whatever. But maybe if it was only a pool of 6, you'd get that acquittal. But the reverse is also true. A conviction could go in the exact same way. You have less opportunity for someone to be the person that says, no, I don't think the prosecution's met their burden here. Lieutenant Lil says, I don't want a panel of 12 cats. They're too judgy. The deliberations would go on for weeks, and then they'd say they're at an impasse. Yeah, a jury panel of 12 cats could probably result in a mistrial because of a hung jury 9 times out of 10. Christy wants 12. Let's see. Mafka says 6 orangutans versus 12 Florida mans. I like the rhyme. So then we've got, let's see what they say. A more prosaic examples are not hard to come by. So there's other things that are still absurd that aren't quite as colorful as the idea, the visual of 12, anything you want to fill in the blank that isn't peers doing this jury thing. So they say we've repeatedly stressed the importance of the interests of the judiciary and the public in correcting grossly prejudicial errors of law that undermine confidence in our legal system. And that interest, for the reasons just given, may be in play when a court is called on to enforce an appeal waiver. Whatever the parties have agreed to, the court's own responsibility is apparent, and so automatic enforcement may risk institutional harm. Again, here's that Mezzanotto case. They're going right to that all the time. For that reason, neither the government's nor the Fifth Circuit's proposed rule can be the right one. The government's maximalist position, remember, this is even if it goes beyond, it violates the statutory maximum sentencing, it should still be enforceable. So here they're like, no. They're like, that can't be the right one. The government's maximalist position first runs into the scenario that even the Fifth Circuit will not tolerate. When a judge imposes on a defendant who signed an appeal waiver a sentence beyond what the relevant statute allows. So then they go off on that. They're like, look, we're just not going to do that. Suppose, for example, that a judge sentences a misdemeanant to life in prison, when the applicable law caps a prison term at 1 year. If an appellate court had to dismiss the resulting appeal, it would call into doubt the judicial system's very attachment to law. But so too would a dismissal in certain other situations, which fall outside both the government and the Fifth Circuit's rules. Consider some examples offered at oral arguments in this case. So if, say, and we're going to listen to these played out, we're going to get through the orangutans, we're going to talk about the condition to not become pregnant, or if the judge, to use a variation on Mezzanotto's absurdity, lets an orangutan pick this sentence out of a hat. Those sentences would likewise impugn the judiciary's integrity if an appeal waiver compelled them to stand. However, certain the parties agreement, I read that wrong. It's however certain the parties' agreement. The courts are too enmeshed in its approval and implementation to escape responsibility for such results. So this is them saying, like, you need to be the gatekeeper when there's some BS here. So we thus approve the majority view among the courts of appeals. So we're siding with the majority in the split, that an appeal waiver is unenforceable when it would result in a miscarriage of justice. That rule sets a high bar. So they go on explaining that the error must be obvious, not one a judge could reasonably make, and it must be of the type that would undermine public confidence in the judiciary. So they're enforcing, hey, look, this is not meant to be everybody can get rid of the sentences and convictions of all the appeals and the plea deals that have come through in our system. It's a high bar. Let's see. Moving forward, because we're going to get to this concurrence, which is just so interesting. And again, they declined to hear in the first instance how the dispute over the forced medication condition, whether that should rise to the level that passes this high to surmount bar that is not insurmountable, but it's very high to get there, or not. They're going to leave that within the Fifth Circuit's discretion to decide, does the forced medication condition fall above or below that bar, right? So it's vacated and remanded back to the Fifth Circuit. So ordered. And let's get into this concurring opinion. This is not the only concurrence. It's the one we're going to look at. If you want to read this full opinion, it is linked in the description. I started reading this yesterday. I didn't read Kagan's writing for the majority until with you guys just now. I was reading this yesterday, and this is the type of thing where I'm like, all right, we're going to get together as a chat and look at this because it's so interesting. It's really informative. And then once he gets through the evolution of plea deals and their use cases, he really points out some critical issues that could deprive somebody of justice and kind of make the process look funky, look a little sus. If we don't consider making certain changes, maybe in future cases where other questions about plea deals and how they're used arise. So hopefully this is a signal that other hot messes involving plea deals, there's several justices that would be interested in hearing them. And remember, we also have concurring opinions. What was it? We're on page 20, right? Was it Kavanaugh? What were the concurrences? Again, what was that breakdown? Yeah, so yeah, Kavanaugh files where Alito and Barrett join, and then Barrett files her own concurrence. So I think that's a very positive signal that this court wants to maybe weigh in on some of the runaway. I've got this quote at the bottom, this conveyor belt of plea bargain problem. I almost said plea garbage. This conveyor belt of plea bargains. Because at some point, it's like plea deals have raised so much skepticism for me personally that I almost, when I hear that there's like a plea deal for a co-defendant in a case, I'm immediately on alert because the way that plea deals have been used, I think it's oftentimes violating the other co-defendant's right to a fair trial. It's blinding the prosecution to the true facts of the case because they're like, hey, if we can just get this other person to agree and say that the other person did it, that's obviously the truth. When maybe that's not the case. Maybe it's just the case where someone wants to be the first one knocking on the courthouse door, knowing that they're facing life. And if they say something first, maybe they'll get out in 15 years. Whether or not they actually did the thing. Maybe they did all the things and the other person was present and had no idea this was going to happen, but let me point it on them. And to me, someone who doesn't care about somebody else is most likely to be the first person to want to run and take a plea deal. And I think it's just, not a good foundation for prosecutors to be like, oh, you're ready to talk? Okay, well, let's just make this work. So I don't like that we have this conveyor belt of a system because there are plenty of occasions where plea deals are actually agreeable to all parties. Plea deals accomplish something good. Um, maybe somebody knows they did something wrong, doesn't want to face going to a jury trial, it's expensive to do, and they can cut a break, and maybe this will be a deterrent for them in the future. The idea that you could have been facing this, but you caught a break, a lot of people will be scared straight by that. I think it's effective. Plea deals can also save a victim, like a surviving victim or the family members of victims, for having to live through the trauma of going through a trial, right? I think there's a lot of good that plea bargains can do. But when everything becomes a plea bargain, it's hard for me to believe that plea bargains are good all the time. So I've become highly skeptical of the way they're being used. So if you're new here, me griping about plea bargains, plea deals is not new. I don't think every single plea deal is bad and unnecessary, but I do have a lens when I hear them come up in a case, especially with multiple co-defendants. I'm like, oh no, is there going to be a hot mess in this case? And then lo and behold, usually the cases we at least tend to watch here seem to always devolve into some kind of hot mess. So let's see what Gorsuch says here. Let's see. We've got, I think Thomas does have an opinion. I didn't look at it though. We can. Let me just see how long it is. Oh, why is the scroll not working? Oh, that was weird. Just like froze. All right, so 6 pages, looks like. His dissent's about 6 pages, and we'll read his first. Her first sentence, get a summary. So the dissenting opinion from Justice Thomas says the court tries to solve this problem through an indirect chain of reasoning. Plea agreements are approved by district courts, and the process by which they do so, the court says, involves a measure of discretion. Thus, the court continues, the question whether to enforce an appeal waiver in a plea agreement, once under consideration in the Court of Appeals, is linked to the district court's initial discretionary process to approve the agreement itself. So the court seems to think it follows that the Supreme Court has inherent supervisory power to prescribe rules for enforcing appeal waivers in the Court of Appeals, flowing from its ability to supervise that initial plea agreement approval process in the district courts. That logic overlooks what is at issue here. The court's supervisory authority may have been understood to reach the judicial procedure for accepting the plea agreement itself. But it does not follow that it includes the power to change the substantive provisions of valid plea agreements once they've been approved and made binding. This case illustrates the problem. Hunter's not challenging anything related to the district court's approval of his plea agreement. To the contrary, he seems to hope that the agreement is still binding, as he suggests that he would resist any effort by the government to reinstate the 9 counts it dropped. He instead simply wants the agreement changed by the Court of Appeals to permit his appeal. But the supervisory power does not permit either rewriting of the parties' contract or changing plea bargaining law, with a footnote that says the court cannot escape this problem by framing its rule as addressing the enforceability of the agreement. Generally, the question, whether a particular agreement is enforceable, has been understood one of substance, not procedure. So even if the court could recharacterize its rule as procedural, it was not the court's place to promulgate it. The committee responsible for developing the federal rules of criminal procedure has declined to advance a rule like this one, and Congress established that rulemaking process to evaluate the costs and benefits of various policy proposals. Whatever the scope of this court's supervisory power, it does not include the power to circumvent the federal rules of criminal procedure. The Rules Enabling Act establishes a reticulated process for the court to alter lower courts' procedures. In this process, the Judicial Conference's Rules Committee recommends rules of practice, procedure, and evidence after an extensive public process. So he's basically saying, like, look, the Supreme Court can't just step in and stomp on something that's we've built into the code, the rules, and then just decide to do something new and ignore all of this. So then, before the Supreme Court adopts the recommendations as binding rules, it must first transmit them to Congress. So he's saying have Congress do. Congress should be the one doing something. Because this process enables thorough consideration of the policy issues, this court is ill-equipped to second-guess those policy judgments while it is merely hearing one case. Recent involvement by the Rules Committee on an issue, therefore, counsels hesitation in invoking our supervisory powers. The Rules Committee has recently addressed appeal waivers. In fact, it has paid close attention to them, advanced rules in this area, and declined to adopt a rule like the courts. In 1996, is that recent? The Rules Committee proposed what is now Federal Rule of Criminal Procedure 11B1N, which requires district courts to explain appeal waivers to the defendant before accepting a plea agreement containing one. Okay, I think this is not following. This is a different sentiment than him. Whatever he was discussing was just recent. He's talking about something else. But I was like, that's not recent. He says it's kind of been established for a few decades now. So he cites to the appeal waivers and future of sentencing policy by N. King and M. O'Neill. Some immediately objected that such a rule would imply general acceptance of appeal waivers, which they opposed because of the risk that significant trial judge errors would be shielded from review. So what he's saying is, hey, this concern was raised. It wasn't a concern that was missed that we didn't consider, that they didn't consider, that this committee didn't consider. It was raised. Several people raised the issue. But yet, the Rules Committee approved the recommendation anyway, which this court accepted and Congress allowed. So now, what SCOTUS is doing today is stepping on the toes of this decision to approve the recommendation. So they say appeal waivers, now seemingly approved by the federal rules, continue to become more prevalent, with a footnote that although the advisory committee said that it was not taking a position on the validity of appeal waivers, the new rule in practice solidified them. So where were we? The Rules Committee, we're here, has remained focused on appeal waivers in the years since. In 2015, the committee heard a proposal to prevent courts from accepting appeal waivers before sentencing. But the committee unanimously agreed not to pursue it. And at the meeting earlier this year, all right, now we're very recent, a member proposed requiring further disclosure to defendants about the consequences of appeal waivers. The Advisory Committee on Criminal Rules, so they cite to it, notes that it was taken under advisement. But even after hearing such proposals, the Rules Committee has not advanced any recommendation to preclude defendants from waiving certain appeals. I actually think this would be a good idea. You know, you could get the prosecution and get what they want. It's more difficult to claim, I didn't know what I was waiving. But why not just make it more explicit to the defendant? Make it more than just, you understand that you give up your right to appeal this conviction or appeal the sentence. I don't see a problem with adding like 2 sentences there to make it more spelled out, flesh it out a little bit more. But this committee didn't want to do it. By effectively legislating, and again, that clarification is something that undoubtedly would be used and leaned on by the government and by the Court of Appeals when they wanted to say, look, we know you're appealing this, but you waived it and you signed off on these 3 sentences saying you understood. Right? So what I'm saying should be there. It's not something that would help like 99% of people try to appeal their convictions or sentences. So by effectively legislating a new rule in this area, the court intrudes on the calibrated policy-making process established by the Rules Enabling Act. The Rules Committee stands equipped to weigh policy trade-offs, collect data, engage in a thorough and exhaustive review of the issue, and craft a rule that achieves fairness for all parties. So therefore, this court should have hesitated before creating a new rule that the Rules Committee could have included in its deliberations on appeal waivers, but chose not to. So finally, the sparse precedents that the court relies on do not justify its miscarriage of justice exception. I'm kind of okay, like, I'm kind of agreeable to this. Like, I get it. Like, I'm happy about the decision anyway, but I'm just saying, like, I can acknowledge the concern. Let's not step on toes. I still prefer the decision to vacate and remand this and set up the safety valve. But here it looks like we're saying, hey, there shouldn't be a safety valve. So when we get to this section, it's like, we shouldn't even have a miscarriage of justice exception. These precedents don't even allow us to have a safety valve. That's very difficult to get to. We still shouldn't have that, is what it seems like this is going to argue. And I just do not agree. In Mezzanato, a defendant sought to be excused from his waiver of certain evidentiary protections. The district court held him to his waiver. The defendant was convicted, and on appeal, this court upheld the conviction and the enforcement of the waiver. Mezzanato's holding, then, provides no support for the court's exception that it creates today. In fact, Mezzanato's reasoning emphasized that, quote, we have presumed that statutory provisions are subject to waiver, and that waivers of evidentiary protections are liberally enforced. So the court today must turn to a single paragraph of dicta. So dicta is just kind of like somebody's yapping, they're riffing. It's not really meant to be, this is my finding, this is my ruling. It's just an observation that I'm making as a judge, but it's not meant to be legally binding. So he's taking a gripe here that, why'd it get little? He's taking an issue here with, look, we're focusing on Mezzanato, which actually says some other stuff. They emphasize that we've presumed that statutory provisions are subject to waiver. But my peers here, the other 8, are relying on a single paragraph that wasn't meant to be binding, which suggested that there may be some evidentiary provisions that are so fundamental to the reliability of the fact-finding process that they may never be waived, before concluding that no such provision was implicated. In its decision today, however, the court makes clear that it does not believe that the right to appeal a sentence is so fundamental that it may never be waived. The court instead confirms that the right to appeal almost always can be waived, but the waiver becomes unenforceable in the rare circumstance of a miscarriage of justice. Because Mezzanato's dicta addresses only protections that can never be waived, it cannot support the court's rule. In Wheat v. United States, this court declined to enforce a different kind of waiver, but it did so based on a requirement in the federal rules. There, a defendant sought to retain counsel who was currently representing his co-conspirators. The government objected to the joint representation due to the risk of conflict of interest. And then the defendant waived his right to a conflict-free counsel. The district court refused to accept the waiver and rejected the defendant's choice of counsel. This court affirmed. Central to its reasoning, we should look at Wheat. That sounds like a dramatic case. Sounds messy. Central to its reason, it's probably like the most boring thing ever. But I'm hearing co-conspirators all want the same attorney. Central to its reasoning, the court explained that the federal rules of criminal procedure direct trial judges to investigate, especially cases with joint representations that may create conflicts of interest, to protect each defendant's right to counsel. The notes of the advisory committee even suggested that a district court could order that defendants be separately represented. So the court affirmed a district court for doing what the federal rules called for. But here, the court remands for evaluation of whether enforcement of a waiver will result in a miscarriage of justice, even though the federal rules say nothing about miscarriages of justice. So I think this is a different comparison. To me, I'm reading this, maybe I'm reading it wrong, but it's like, hey, in one case, we decided, look, the rules say this, and thus we're going to affirm something. We're going to affirm the lower court who said this is a conflict of interest, and we're not going to agree that a defendant can just waive this. And then he's comparing that as if, hey, because we took a rule and said it calls for this, and we think you correctly followed that rule, so we affirm. He's comparing that, hey, when we don't have an explicit rule in the rules, we shouldn't just not affirm. It's almost like he's saying we should affirm because there's an absence of something explicitly being expressed in the federal rules. And I don't think that that's the same. I don't think A is the same as B here. But he says without any legal justification for its rule, the court appeals primarily to the policy instinct that unfairness could result from its far-fetched hypotheticals. Surely, the court reasons, a defendant must be able to appeal a sentence selected by an orangutan. Tang. I disagree with any insinuation that the only thing stopping federal judges from violating their oaths is the possibility of a sentencing appeal. I also disagree with the assumption that the problem of possibly erroneous trial courts can only be solved by possibly erroneous appellate judges. The government even notes that it can decline to enforce waivers if an egregious injustice occurs. So let the government decide. If somebody appeals, leave it in the discretion of the government. If somebody chooses to appeal, let the government decide whether or not to enforce that appeal waiver. And let them determine if they think an egregious injustice occurs. I don't have faith in that. I don't have faith in that one playing out. I don't think this is in an ideal world. I don't know about that one. So that's what was said he's relying on the brief of the United States in this case. There were no criminal appeals for over 100 years of American history, and our legal system did not descend into chaos. Well, because nobody could see the sausage after it was made. And nobody could say the sausage was made badly. So how could there be chaos? Doesn't mean it was right. What? Like I said, I have an appreciation for the first half of his argument, but I am lost in the second half. This is not a cat. This is not something Cat's sympathetic to. I'm not even trying to speak in the third person. Oh, but just saying, I'm lost on that one. Technically, there was no chaos, but does that mean it was a good thing just because there was no visible chaos? Okay, anyway, moreover, the court's policy reasoning overlooks important drawbacks to its approach. For one thing, it is not obvious that this rule will provide fairness to defendants. After all, in the long term, uncertainty about whether an appeal waiver will be enforced eliminates a bargaining tool to convince the government to drop pending charges. So now this is I'm looking out for the defendants. If we get rid of this, then prosecutors will be less likely to bargain. Or at least bargain in a way that would be more favorable to the defendant through means of, we're going to null pros certain charges if you agree to plead guilty to this one charge. Plead guilty to this misdemeanor, we'll drop the felonies. And if we remove this appeal waiver to know that there's finality here, prosecutors will not want to offer such a thing. That's the argument here. And I don't think that that's meritless. I just don't really think that it's much more important consideration than the idea, hey, if there is like an absurd sentence or an absurd conviction resulting from a plea deal, that shouldn't matter. We shouldn't do an appeal, because if we got rid of that, the bargaining chip could be at risk. It's here, but it's not significant enough to me to outweigh the other issue that we're here for. So we've got defendants like Hunter, but I like to think about it. I'm not gonna lie. I'm glad we're reading this because it's making me think about what's being said here. What's the counter argument? Defendants like Hunter, therefore, may have to forgo other valuable consideration to obtain similarly lenient sentences. he put in quotes, a sounder approach is to permit the interested parties to enter into knowing and voluntary negotiations without any arbitrary limits on their bargaining chips. That's from Mezzanato. For another, the court's approach may lead to a flood of new meritless sentencing appeals. I mean, they could still be declined pretty quickly. You know, this level of gatekeeping isn't something that, like, you can gatekeep it and shut it down right away. So yes, maybe you'll get a larger volume, but it's not like each of those meritless appeals goes on to a point where the court has to waste time hearing the merits. It can be nixed right away. So it might be high in number, but it's not like where we think of some appeals, like there's arguments, there's hearings, it takes up a lot of the court's time and resources. Each of these attempts to appeal, I just don't think it would be the, you know, I don't know. You either get what I'm saying or I don't, because I can't articulate it better. I don't think it's the most exhaustive use of resources just because there would be a larger number. One study concluded that as of 2003, 65% of plea agreements in federal cases contained appeal waivers. Of agreements with a waiver, 80% waived both direct appeals and collateral attacks under Section 2255. If these numbers have remained steady over the 2 decades since, okay, because that rule I think was like 1996 or something, right? That we read about earlier. So this study would be after that rule came about. If these numbers have remained steady over the 2 decades since, and I have no reason to doubt it, the consequences of today's decision for the Federal Court of Appeals are sobering. Last year, over 76,000 defendants pleaded guilty. That's from the Administrative Office of the U.S. Courts, U.S. District Court's Criminal Statistics Table for the Fed Judiciary from 2026, Table D4. This is where I wish we had a hyperlink we could just click and open up. Over the last 10 years, more than 680,000 defendants have pleaded guilty. That's more than 500,000 in half a decade. So let's see. It says that's from the Admin Office of the U.S. Courts. Between defendants who can appeal and prisoners who can collaterally attack already final sentences, it is not hard to imagine 100,000 claims that should be barred by waivers that will now be filed in reliance on the court's exception. The court's efforts to keep this exception narrow may make it hard to succeed on these claims. Accord, and he cites Kavanaugh's concurring opinion. But a miscarriage of justice will always be easy to allege. The courts of appeals will now have to sift through many appeals, even though miscarriages of justice are, as the court admits, rare. I don't know. I don't think that outweighs the need. Like, should there not be a safety valve for absurd outcomes that just impugn the integrity of the judiciary? Just because there'd be a higher entry point, there'd be a higher volume at the very top level of the entry point funnel, which can be nixed relatively quickly. So again, I don't think the plain, sentiment here that, hey, more people will try, they'll hear about this, they'll try to say, like, look, screw the waiver I signed off on, let me file an appeal. I don't doubt that. I agree that will happen. I don't know how much it'll happen, but do I think it's significant enough to outweigh the purpose of what we're doing here today? Nope. No, I don't. And then they say, ultimately, though, how I weigh the trade-offs between, and like, think about how many cases of, like, things that happened 6 years ago. A lot of those pleas might be, like, the time might be done already. Not every plea is, like, something that results in significant time. A lot of pleas maybe get, like, no time in prison, no time in custody, no time in jail. You just do some probation. Maybe it's like 2 years of probation. So a lot of that 600 and whatever thousand, the over 500,000, maybe that a lot of that's already played out and exhausted. And some people will appeal on principle, like, hey, I shouldn't have had that in the first place. I think it was wrong. But I really don't think that large of a number of people here are dealing with, like, 5-year plus in custody, still in custody. I just don't see anywhere close to 680,000 people coming in and flooding the Court of Appeals. And even if that's the case, maybe it's worth it. Is it worth it for if 1%, 2%, 5% of this number has some type of absurd conditions of their sentencing? I would say it's worth it, because that shouldn't stand. Just because we try to hide the chaos and deny the opportunity for chaos to present itself doesn't mean that bad things, wrong things, absurd things exist. So then Thomas goes on to say, ultimately, though, how I weigh the trade-offs between the risk of a rogue district court judge issuing a lawless sentence, the diminished utility of the appeal waiver bargaining chip, and the potential flood of new appeals should not matter. In the absence of a legal principle saying otherwise, Hunter's plea agreement and appeal waiver are valid and should be enforced. So he's basically saying, like, the sections B, C, and D that we just read are like, he's opining. He's like, but that's not really the relevant point. That first section where it's like, hey, we don't have a legal principle that supports this. That's really the bigger point. So he concludes that Hunter knowingly and voluntarily agreed to waive his appeal rights, and the exceptions he preserved are not implicated here. Accordingly, I would enforce his agreement and dismiss his appeal. I respectfully dissent. All right, let's go to page 20. Let's go to Gorsuch. So we detoured there. Let's go to Gorsuch. And I actually think this will be better to read. So Gorsuch here, why did I jump? Is there a way I can get rid of this pencil? Because when I click the undo, it's like making me jump. I just won't click it. So Gorsuch is the part that I read. I read most of it yesterday. I didn't finish reading it, but I read most of it, and I'm like, oh, I think we should talk about this. This is cool. This is interesting stuff. It's just like, it's like trivia. It's like a lot of, to research and learn this. It would take some time, and he kind of spells out the evolution of the weaponization of plea deals, this conveyor belt that we now have. And I agree with that characterization. That's often what it feels like. And now that we read Thomas's dissent, I think what Gorsuch is going to point out here, it kind of fights more directly on this is why we think having a safety valve is so significant. So I think it's good that we did that in that order. So we've got Gorsuch here, Sotomayor, and Jackson join. In our times, the jury trial has given way to a conveyor belt of plea bargains. At least some responsibility for that development lies with this court. When confronted with coercive prosecutorial tactics designed to induce defendants to take plea deals, the court has often condoned those practices or let them pass in silence. Today, the court begins to correct course. So, this to me is a signal we want more. It rules that prosecutors may not always leverage their plea bargaining power to induce a defendant to forgo the right to contest his sentence on appeal. I agree, and write separately to outline how we got here and some of the work still ahead. Because the facts of this case are emblematic of many others, they're worth pausing over. So he's going to go through the recitation of the background on this particular case. So we've got, in 2023, the federal government secured a 10-count indictment against Munson Hunter for his alleged role in various fraudulent transactions. 4 of the charges focused on a single transaction, while the remaining 6 focused on others. Altogether, the government charges threatened Mr. Hunter with up to 300 years in prison and a $10 million fine. After bringing, so that's the exposure, right? The maximum exposure. That is the risk you're facing if you take it to trial and the judge sentences you to the allowable maximum. 300 years in prison, so bye-bye, and a $10 million fine. After bringing these charges, though, so you're like all the way out the ballpark here. That's what you're facing, but we're going to bring you an offer. So prosecutors offered Hunter a deal. If he agrees to waive his right to a trial and plead guilty to 1 count of wire fraud based on a single transaction worth $38,648.77, prosecutors said they'll drop the remaining charges against him. Unsurprisingly, Mr. Hunter agreed. Ultimately, the deal the parties struck also included an appeal waiver. By its terms, Mr. Hunter waived not only his right to appeal his conviction, he also waived his right to appeal whatever sentence the district court might later impose. After the district court signed off on the parties' deal and accepted Mr. Hunter's guilty plea, it turned to the question of an appropriate sentence. While Mr. Hunter pleaded guilty and admitted to stealing the $38,000 in one transaction, the district court proceeded to sentence him as someone who stole $488,352.25 in 26 transactions. Oh. So it seems like maybe in calculating the tables, because they're citing here the pre-sentence investigation report. I don't know. See, we didn't get this context. And I think I skipped this when I was reading the opinion. I don't remember reading these numbers. I might have jumped further down. I was probably like, oh, the procedural history, what happened to the case? Let me skip these and see what else we talk about. But I believe that's new context here. And I don't know, I feel like that's kind of a problem. Because your conviction, sentence should be based on conviction. Where is this coming from? That was a horrible circle. So they say some of these additional funds and transactions were the subject of counts the government agreed to dismiss in exchange for Mr. Hunter's guilty plea. Other funds and transactions were not even the subject of the government charges. See, man, this is that BS. This is that BS. Like, what good is a negotiation and an agreement? We're going to drop these things if you're going to get, like, sentenced in relation to those charges that are dropped anyway. This made a significant difference for Mr. Hunter. Had the district court sentenced him based on the amount he had pleaded guilty to stealing, he would have faced an advisory sentencing guideline range of 15 to 21 months in prison. That's a big difference compared to 300 years. That's like a year and a half, approaching 2 years is the range. So, I mean, and again, I'm glad we read the Thomas opinion, because if we care so much about the state having a bargaining chip, and we're fighting to preserve that bargaining chip, which can benefit a defendant because they can get these lesser sentences. But this is how it played out in this very case. Is this the take at face value Thomas's bargaining chip argument? It makes some sense in an ideal world, in a bubble. But even in this very case, that idea of a plea bargaining that's going to be helpful for the defendant, it doesn't work. Because they bargain for this, and it's agreeable to both parties, and yet the judge does something else anyway. And this isn't even really an issue that SCOTUS weighed in on. So what's the point of preserving the bargaining chip power and arguing that it's good for the defendant if we don't get there? See, this is why I shouldn't skip things when I read. I totally missed this yesterday. Now, though, he faced a recommended prison term of 41 to 51 months. All right, so we're at like, that was like the Diddy original sentence, right? 51 months? 56 months? 51? So, but it's approaching, what is it? 5 years, 6 years? So, just over 5 years there. And based on that calculation, the district court chose a prison sentence of 51 months. So they went for the max. So based on the recommendation, the range that was recommended, they chose the highest in that recommended range. The result, a guilty plea to a single charge, enabled prosecutors to secure a punishment based on other charges they'd agreed to drop or had not even brought. I think Gorsuch is cooking. I think he's cooking. I think we're going to see him cook more. I didn't read this part yet. But like this last sentence here spells it out. And that was not all, there's more. The district court ordered Mr. Hunter to serve time on supervised release after leaving prison. As part of his supervised release, so it's not like his term was only 51 months. It was 51 months in custody and then also more on supervised release. On this, the court directed Mr. Hunter to comply with various conditions, one of which is of special relevance here. It arose this way. Before sentencing, Mr. Hunter met with a probation officer. There, he self-reported a history of mental health diagnoses. As it turned out, and it looks like the United States, in their reply, relied on that. So they were trying to point to, well, he self-reported he had these issues. As it turned out, that honesty came with a price. At sentencing, the probation officer urged the district court to require Mr. Hunter to participate in a mental health treatment program and take all mental health medications that are prescribed by his treating physician while on supervised release. Mr. Hunter objected to one part of this recommendation. He did not dispute that he has suffered from mental health issues. He even said that he wanted to take mental health programs. But he added, I don't want to take medication. I don't drink. I don't use drugs. I don't even curse. I don't want to have to be forced to medicate. In response, the court did not find that forcing Mr. Hunter to take psychiatric medicine against his will would further any particular goal of criminal punishment, but it imposed the condition anyway. So, yeah, I think this is interesting because I read this part yesterday and I was like, well, if you're not finding that this would be important for, you won't reoffend, it's necessary for the safety of the community. It seems like we have no findings that justify this basis. He just imposes it anyway. But now I'm understanding that he's imposing this with that 51 month of incarceration, the top of the recommended range, even though all of these other charges were dropped and he should have been facing something more like 15 to 21 months. And then we also add this as a cherry on top. After sentencing, so this to me is getting into absurdity in a way. Like, what faith can a defendant have in the plea bargain? Oh, sorry, I have a comment blocking. My bad. I think that was Bray on the screen or Lil Montana. Shout out to whoever was on the screen for like the last 20 minutes. After sentencing, Mr. Hunter sought to appeal the district court's forced medication condition to the Fifth Circuit. There, he pointed to this court's decisions, holding that individuals enjoy a constitutionally protected liberty interest in avoiding the unwanted administration of antipsychotic drugs. Under those precedents, he argued, the district court could not constitutionally force him to take psychiatric medication, absent compelling evidence that it was necessary to promote a valid sentencing-related interest. And he submitted the district court had no compelling evidence before it that forcing him to take psychiatric medication would advance a legitimate penological interest associated with his crime of stealing $38,648.77. The Fifth Circuit dismissed the appeal. In doing so, it assumed that the district court had committed a constitutional error in ordering Mr. Hunter to take psychiatric medication. Even so, the Court of Appeals held it was powerless to say so. Because Mr. Hunter had agreed to an appeal waiver, the court concluded it couldn't hear his case. And this is what I'm saying. Like, how much time did this waste of the court? So if hundreds or even thousands of petitioners spread across the country decide, look, we're going to appeal this plea that we agreed to, how much time is really going to be eaten up by that if we can stop it at the front lines? So the most remarkable thing about Mr. Hunter's plea bargaining journey may be how unremarkable it is. Our criminal justice system is no longer dominated by trials and sentences based on them. So this is a section we're going to go through the history, and I think it's so interesting. But plea bargains that work out in ways not unlike his own. Of course, it was not always so. At the nation's founding, the right to a trial by jury was considered part of every American's birthright and inheritance. Outraged by British efforts to deny, dang the British, outraged by British efforts to deny that right in the colonies, those who fought the revolution cited its suppression as one of their reasons for declaring independence. They cite the Declaration of Independence here. After the revolution, too, the founding generation took care to secure the right to trial by jury in criminal cases, not just once, but twice in the Constitution and Bill of Rights they adopted. Really, it seems plea bargains don't begin to emerge as an alternative to trial in serious criminal cases until the mid-19th century. Plea bargaining as coercion, that's what they're citing here by McCoy. It says C. McCoy. And even then, the practice usually met with intense judicial skepticism. Many judges considered the idea that the jury right could become the subject of an agreement between the prosecutor and the defendant abhorrent. So they cite some Some sentiments there from non-negotiable features of criminal litigation. It was written in 1999, and it collected a bunch of cases. And then Plea Bargaining and Its History by A. Alschouler. That skepticism continued well into the 20th century. In Walker v. Johnston, 1941, this court held that a defendant is deprived of a constitutional right whenever he is deceived or coerced by the prosecutor into entering a guilty plea. The prosecutor's alleged tactics there: obstructing the defendant's effort to hire a lawyer, showing the defendant pictures of the scene of the alleged crime, seeking to persuade him that he would be proved guilty, and warning him that he would be sentenced to twice as great a prison term if he did not agree to plead guilty. So Gorsuch is pointing out that, look, this court, years, decades ago, said that these tactics by the prosecutor constitute a deprivation, constitute deception, constitute coercion. And it should not stand. Should not stand. So, like, the idea of, someone about to go to trial and somebody's telling them, if you go to trial and you're convicted, the only way you're leaving is in a pine box. I have to sentence you to life. You will get life if it's the prosecutor telling them, even though the minimum exposure is way less than that. That's deception. That's pressure. That's coercion. It's a deprivation of someone's constitutional right. Shouldn't be doing that. The court repeated the message in Macabrota v. United States. A guilty plea is void, the court ruled, when it is induced by promises or threats which deprive it of the character of a voluntary act. There, too, the court expressed no doubt that a defendant is entitled to have his sentence vacated when a prosecutor promises a certain sentence in exchange for a guilty plea, discourages the defendant from communicating with his attorney about the plea offer, and threatens the defendant with additional charges if he, quote, makes a scene before sentencing. Eventually, though, this court took a dramatic turn. In 1971, it proclaimed plea bargaining highly desirable, something to be encouraged, and an essential component of the administration of justice. That's from Santabella v. New York. If every criminal charge were subjected to a full-scale trial, the court worried, the states and the federal government would need to multiply by many times the number of judges and court facilities. And they cite back to the Brady case mentioned earlier. Upholding the validity of a plea entered pursuant to a sentencing scheme the court had invalidated as unconstitutionally coercive just 2 years earlier. And then we've got Borden-Kircher v. Hayes, 1978, illustrates the kind of coercive tactics this court became willing to stomach in the name of facilitating plea deals. That case began when authorities indicted Paul Hayes, a Kentucky man, for forging an $88.30 check. Punishable by, well, how much was $88 back in 1970s? So this was punishable by 2 to 10 years in prison. It's kind of a broad range. That's what he could have been exposed to. But the charge led to plea negotiations. If Mr. Hayes would save the government from the, quote, inconvenience of a trial, the prosecutor offered to recommend a 5-year prison sentence. And now, like, this is usually worded more artfully. Like, it'll be worded as in the interest of justice. Rather than, oh, the inconvenience, woe is us. Right? It'll be worded as in the interest of justice. They'll say, like, efficiency. They'll usually use more artful wording than just like, that'd be inconvenient. The prosecutors offered to recommend a 5-year prison sentence. But if not, the prosecutor warned, he would return to the grand jury and seek a further indictment under a Kentucky 3 strikes law, carrying a 3 sentence. So look, you're facing 2 to 10, I'm going to offer you 5. That's kind of like, well, I don't know, risk versus reward there. Even if I get 10, I mean, maybe it's worth the risk of going to trial. But then you add in this mix, if you don't do this, I'm going to go and secure an indictment that will make the 3 strikes law apply. And you'll go away for life if you get convicted. Is this how the bargaining chip is supposed to work? Yes, judicial economy. Shout out to Adventure Aaron. Is this how the bargaining chip is supposed to work? Is this the bargaining chip that's supposed to be helpful to the defendant who might want leniency, who might want and be agreeable to foregoing a trial? We won't do this if I get a little bit less. I get it. I did something wrong. I'll plead guilty. Thank you for giving me less time and understanding. That's not the ideal world that this plays out in. This is a great example. If you don't take this plea deal, which isn't necessarily that great, because maybe I'd only get 2 years even if convicted, and you want me to plead to 5. You're going to threaten me with securing a further indictment that could expose me to a life sentence. I don't think this is how the bargaining chip is supposed to work. And I certainly don't think it is helpful, it's good for the defendant, or in the interest of justice. When Mr. Hayes refused the deal, the prosecutor proved true to his word. He sought and secured the new indictment as promised. And after a jury convicted, Mr. Hayes received a life sentence. In a decision perhaps unthinkable only a few decades earlier, this court in Burden-Kircher endorsed the prosecutor's tactics. However things might work in an ideal world, the court said, the fact is that the guilty plea and the often concomitant plea bargain are important components of the country's criminal justice system. As the court saw things, prosecutors need room to issue threats in plea bargaining, even when it means threatening a life sentence for a forged check worth less than $100. So in their decision, they enforce that this is exactly. We need the plea bargaining chip to be able to work this way. We need the legroom. We need to allow this legroom. With this specific example of 2 to 10 years of exposure suddenly becomes life if you don't agree to the original plea deal. Unsurprisingly, prosecutors quickly began taking full advantage of this new judicial latitude. The collapse, they cite here W. Stuntz, The Collapse of American Justice, Criminal Justice. They threatened lawyers of additional charges and decades of additional prison time if defendants dared to exercise their right to trial by jury. Prosecutors sometimes promised charges against defendants' spouses and parents too. We have a quote that says, threats that would be deemed extortionate outside the plea bargaining process became par for the course in our criminal justice system. To be sure, this court is not wholly responsible for these developments. Other causes are at play as well. Since the 1970s, the number of federal criminal laws has grown rapidly. The prison terms attached to federal crimes have also grown. Some now say there's not an adult American who has not committed one felony or another. So I think the point here is there's always a way that somebody could threaten you with a more serious crime just to get that leverage. They cite here D. Husak, Overcriminalization, the Limits of the Criminal Law, 24. Maybe, I guess there's 24 of these. Federal sentencing guidelines as well currently recommend higher sentences for most defendants who exercise their constitutional right to a trial. And while prosecutors once felt constrained by the traditional maxim that an indictment should not include more than one felony, today's prosecutors often bring as many overlapping felony charges as they can in a single case. And they cite here, this is a case Barrett v. United States from 2026. And does he cite his own concurrence? He cites his own concurrence. Together with this court's approval of aggressive negotiating tactics, developments like these have made it easier than ever for prosecutors to cajole defendants into pleading guilty. That's another word that I've heard pronounced both ways, so you'll probably hear me switch it if we have to say it again. So much so that perhaps 95% of convictions now come by way of plea bargains. And he cites here R. Barkow, Justice Abandoned from 2025. 95, perhaps 95% of convictions now come by way of plea bargains. Take care, Charles. Have a good one, Charles. Hey, Sharon. See some new faces. I see Dee's in the building. Hey, Dee. I see some emojis. See some emoting going on in the chat. Runray says, hey, that sounds like intimidation, which is a federal crime. I think you said this right before we got to, hey, these things would be extortionate outside the context of a plea bargain. So what are we doing here? My goodness. Hey, FFS. Hey, Wild Goose. Wild Goose. Let's see. I see lots of conversation. Hey, maybe Megan, maybe not. You can't see me. I can see you. And Michael, good to see you, Michael. Okay, I think looking for other new names. There we go. Good to see you guys. The gang's all here. All right, so where was I? All right, so these days, plea bargaining is not just some adjunct to the criminal justice system, it is the criminal justice system. And that is from 1992. If plea bargaining on this scale and in this manner is a modern phenomenon, appeal waivers represent a more recent development yet. Pursuant to an appeal waiver, a defendant usually must agree to waive not only any right he may have to contest his conviction on appeal. Typically, he must also agree to waive his right to appeal any sentence a district court might issue after accepting his guilty plea. So you agree, and then you've still got mystery. A defendant must do so even though he does not yet know what that sentence will be. And he must do so even while the government retains its rights to appeal any decision it doesn't like. 40 years ago, appeal waivers like these were rare or non-existent. So basically, if a judge comes in and is like, you know what, here's the range, I'm going to go with the low range. If the state gets mad, if the prosecution gets mad, the government gets mad, they can appeal that. But the defendant can't. And that seems unfair. That seems unfair. Maybe there should be, like, if there's like a very high bar to contest an appeal waiver as unenforceable, maybe there should be a constraint down here where the state can appeal, but it has to be something that's absurd on the flip side, right? Like if somebody is charged with something where they should, it's just like you do a bunch of stuff that's really bad, it should carry a serious time. You take a plea, you're supposed to get like 15 years, and the judge is just like, bye, you're good to go. Like, sure, I'm fine with the state being able to appeal that. Like, what are we doing? But if they have this like broad stroke right to appeal anything that they don't like, I think that's imbalanced. I think we've got to balance it. But you know, typically this is just how things seem to go. So they say these things used to be rare or non-existent, but today they're commonplace. Consider what this means. Because a defendant confronted with an appeal waiver during plea bargaining does not know what sentence a court will issue, he must negotiate in the dark. What if, as the Fifth Circuit assumed here, the sentencing judge imposes a punishment the Constitution does not tolerate? What if the judge fails to respect this court's precedents and Congress's statutes governing how he must proceed at sentencing and what punishments he may lawfully issue? What if a judge goes so far as to allow an orangutan to pick the defendant's sentence from a hat? As the government tells it, a defendant with an appeal waiver has no way to correct any of these errors on appeal. Yes, even when it comes to the orangutan. And yet, because an appeal waiver may often be bundled together with other terms in a plea deal in a take it or leave it package, a defendant may often have little choice but to accept risks like these, especially given the consequences prosecutors can visit on those who refuse, like going and getting a whole new indictment. Much as plea bargaining initially met with judicial skepticism, so did appeal waivers. Some district court judges refused to accept plea agreements that included appeal waivers or struck those waivers completely. And I cite a few cases, but with time and subject to differing exceptions, courts of appeals largely came to accept appeal waivers, much as courts had previously come to accept plea bargains themselves. For its part, this court allowed debates over appeal waivers to proceed in the lower courts for years without comment, offering no statement on their legality or on what particular exceptions may be required. Today, the court breaks its silence, agreeing with Mr. Hunter and certain courts of appeals. It holds that an appeal waiver is unenforceable when a defendant seeks to appeal a sentence that represents a miscarriage of justice. To illustrate what this standard means, the court offers some examples. At the same time, the court takes care to emphasize that these examples are not intended to be exclusive. All that is a welcome first step, but it also leaves lower courts considerable work ahead to flesh out the standard the court announces. Fortunately, it seems to me that decisions from the Court of Appeals that already apply the miscarriage of justice rule that the court approves of today along with certain of our own existing precedents, can help illuminate the path forward. Start with the court's first example of a miscarriage of justice, a sentence exceeding what the relevant statute allows. Or put another way, a sentence that's not authorized by law. This category, of course, embraces sentences that exceed the maximum prescribed by statute. But consistent with lower court decisions, the category should likewise include sentences imposing penalties the law reserves for offenses different than those of which the defendant stands convicted. And they cite Phillips here, a ban on receiving federal benefits, or ones that order remedies the law does not permit. And they cite States v. Young, that deals with restitution. And perhaps mandatory minimum sentences for which the defendant does not qualify. Now take the court's next example, a sentence premised on a blatant constitutional error. As the court explains, that includes not only sentences based on constitutionally impermissible factors such as race, religion, or sex, it also extends to constitutionally infirm conditions of supervised release. Accordingly, a defendant may be able to appeal a sentence imposing a condition of release that violates his right to be free from forced medication, or a condition that violates his right to speak or worship freely, or any other condition that violates one of his recognized constitutional rights. Really, I would think a miscarriage of justice all but certain to arise whenever a sentence infringes a constitutional right that was firmly established at the time of sentencing. Next, consider the court's third example, sentences marred by serious procedural errors. That includes not only a sentence chosen by an orangutan, but others reflecting a marked departure from mandatory sentencing procedures. And then we've got appreciating as much. Courts of appeals have often declined to enforce appeal waivers when a district court breaks from rules requiring it to give reasons for its chosen sentence or address the defendant's non-frivolous arguments for a different one. Consider also aspects of sentencing that can require a degree of judicial discretion. The application of the advisory sentencing guidelines, the imposition of supervised release conditions within statutory and constitutional bounds, and the weighing of 18 U.S.C. Section 3553A's sentencing factors. There was just a recent SCOTUS case, well, it was probably like a year ago now. What was that case? There was a circuit split on whether the language, if it wasn't explicitly stated in this section, what was that case? Could a judge consider it? And some circuits said yes, and others said no. Right? I think that case was in the last year. Circuit split. I don't remember the name of the case. Asteris v. United States, June 20th, 2025. Oh my God, tomorrow that would be exactly 1 year. I was close. And they ended up holding 7-2 that district courts may not consider Section 3553A2A retributive factors when deciding whether to revoke a term of supervised release. Very interesting, but kind of like narrow interest case. But I thought it was very interesting arguments, good oral arguments. I want to check that one out. It was Asteris v. United States. I don't remember if I feel like I might have streamed those oral arguments, but I don't really remember. But they're out there. Someone's got them uploaded on YouTube. I might have a video on it. I don't remember. But yeah, Asteris v. United States recently addressed some issues with this. I appreciate that standard fare errors in those areas will not often clear the high bar that the court sets today. But some errors may. For example, and as we've held, the failure to correct a plain and non-harmless error in calculating an advisory guidelines range ordinarily will seriously affect the fairness, integrity, and public reputation of judicial proceedings. Indeed, what reasonable citizen wouldn't bear a rightly diminished view of the judicial process and its integrity if courts refuse to correct obvious errors of their own devise that threaten to require individuals to linger longer in federal prison than the law demands? A miscarriage of justice would seem to arise as well when a district court metes out punishment that is so substantively unreasonable that it would fail under the deferential abuse of discretion standard that appellate courts already apply in sentencing challenges. Along those lines, lower courts apply the miscarriage of justice rule, have acknowledged this is the side of the circuit split that already had the safety valve and used it. Those courts have acknowledged that egregious harm necessarily results from any supervised release condition or any other component of a sentence wholly unrelated to legitimate sentencing purposes or lacking in rationality. And they give an example here, United States v. Velez-Luciano, involving a highly invasive medical procedure that has no efficacy. So did they order? Oh, okay. And so he's addressing, Kavanaugh must have talked about this in his concurrence, because the footnote says, to the extent Kavanaugh believes the foregoing discussion contemplates a lower bar than is appropriate, his unexplained disagreement lies not with me, not with the opinion I'm writing here, but with what many lower courts and this court have said in the past about what kinds of errors represent miscarriages of justice or otherwise reflect adversely on the integrity of the judiciary. Okay, so that's that footnote. Yeah, Gorsuch says, I wonder too if there are even deeper problems lurking here. Yes, as Mr. Hunter argues, an appeal waiver is unenforceable when a defendant seeks to appeal a sentence that represents a miscarriage of justice. And yes, to resolve today's case, that's all we need to decide. But as the court recognizes, appeal waivers may raise other problems as well. Consider just a couple of them. So now we're going to get into like specific grievances, concerns, issues that can be caused by the way plea bargains are used. Also, do I see any new faces in here? Let's check in on the chat. Hey, therapist, have a safe drive. Oh, okay. Let's see. Wild Goose. I think BB, you mean Broken Baker. Shout out to Broken Baker. Good to see you. Hope you're doing well. Sure, Baker was doing something fine. Let's see. 13th KNW juror. Love the name, of course. Thank you for being a member 19 months. Thanks for sharing your Friday with us, Kat. Well, thank you for being here. Thank you for being here. Are you an orangutan? Mr. or Mrs. Juror, are you an orangutan or a human being? And are there 12 others ready with you if somebody, in fact, wants a trial with a jury of orangutans? My goodness. We've got, oh, just made you guys big. Also, VMCYK. I don't know if I'm supposed to, like, if there's, like, a word that this is supposed to spell. So I'm going to say VMCYK to make sure I don't butcher it. Thank you for becoming a member. Big, big thank you. And then we've got, yeah, Aaron found it. Thank you, Aaron. Aaron linked Stream on Oral Arguments in Asteris. Yes, I couldn't even remember. I remember watching it. I remember the case, but I just could not remember if we did that one up here on YouTube. Kind of niche, but I enjoyed hearing it. It's the type of thing where, say, for example, your sentence for incident A. You do something bad, incident A, or maybe you're innocent and just take the plea deal, who knows. Whatever it is, you are sentenced for issue A. You get a sentence, you get this conviction, and you have a term of supervised release attached to your sentence that you need to carry out. While you're on that sentence, let's say you violate the conditions, and then you have a revocation hearing because of that violation. And let's say that revocation is caused by you, let's think of something that's so taboo, so like nobody wants to hear that you're doing this type of thing, like a sexual assault, right? You do this issue B, something so gross and heinous to hear about, even though you should be assumed innocent until proven guilty on that charge. But it becomes the subject of a revocation attempt of whatever the terms of your supervised release are for incident A, your sentence resulting from whatever happened with case A. Can the judge, in reevaluating how to revoke your current terms, maybe reevaluate what they're going to do, can they consider the nature of that violation when deciding, look, you're not supposed to get in any trouble at all. We're here today because you got in some trouble and the state filed to revoke your terms of supervised release. Can we consider what you're accused of and decide, look, we gave you 5 years of supervised release and suspended like a 15-year prison sentence for whatever happened with case A. Now we're just going to give you those 15 years because we think it's so disgusting that you're accused of what's going on in case B. Can we consider all of those things? And so that's what Asteris dealt with. A circuit split on Some circuits said, nope, you can't consider what's not expressly stated in Section 3553. And other circuits were like, well, it doesn't really constrain, so you can consider other factors. So very, very interesting. Thank you, Erin, for sharing that. Where was I? Okay, so the due process clause of the Fifth Amendment, right? I was here. Right, he wonders if there's deeper problems lurking. As Mr. Hunter argues, an appeal waiver is unenforceable when a defendant seeks to appeal a sentence that represents a miscarriage of justice. And yes, to resolve today's case, that is all we need to decide. But as the court recognizes, appeal waivers may raise other problems as well. Consider just a couple of them. The Due Process Clause of the Fifth Amendment, this court has held, tolerates only voluntary and knowing guilty pleas. That standard is met only if the defendant intentionally relinquishes or abandons known rights or privileges. A guilty plea, thus, must be made both knowing voluntarily and with full understanding of the consequences. It's a rule that means a defendant signing a plea agreement containing an appeal waiver must voluntarily abandon not just his right to trial, but his right to appeal his conviction and sentence as well. And he must fully understand the consequences of that decision. An appeal waiver, like the rest of a plea agreement, must be knowing and voluntary to be valid. And then we cite here United States v. Davis from 2019, holding that the first essential of due process is fair notice. Those principles may pose an independent problem for appeal waivers that purport to insulate sentencing errors from review. After all, and as a district court acknowledged in this very case, when defendants like Mr. Hunter sign plea agreements containing appeal waivers, no one knows what sentence the court will impose. So, are you on fair notice? If the fair notice, you should expect that a trial judge is not going to give you a sentence that's like unconstitutional or absurd, right? You would just reasonably expect that. But if they do, and you sign a waiver that precludes you from appealing that sentence, were you on fair notice when you agreed to that waiver that the judge could do something irrational, absurd, unreasonable? So they say, given that, how can a defendant know and fully understand at the time he signs a plea agreement that a court might later order punishment that defies the Constitution, a federal statute, or this court's precedents? Don't the parties generally expect that a sentencing court will act consistently with the rules of law then in force? Of course, district courts must discuss and appeal waivers' general implications with the defendant before accepting a plea agreement containing one. And that's from the Federal Rules of Criminal Procedure, 11B1N. But the colloquy in this case did not include, nor does anything in the federal rules contemplate, a warning that the district court might later violate the law. For good reason. A legal system branded with a disclaimer that its judges might violate the law would be no legal system at all. Yeah, so we don't want to have warnings all over that our judges might be corrupt, inept, dumb, incompetent, unjust, unfair. And we don't want this disclaimer. What's the point of having a system at all if that's what you're going to be subject to? Notably, too, this court has found prospective waivers of many other statutory rights invalid and unenforceable. We've held that a company's prospective waiver of its right to remove lawsuits to federal court, extracted as a condition of doing business in a state, not just void, but repugnant to the Constitution and laws of the United States. We've held that an employee's right under Title VII of the Civil Rights Act of 1964 are not susceptible of prospective waiver. The same goes for rights under the Fair Labor Standards Act of 42 U.S.C. 1983. Now, we've got a couple cases here. And we have similarly suggested on multiple occasions that a private agreement might not be enforced if it operates as a prospective waiver of a party's right to pursue various other statutory remedies. And again, a lot of the oral argument talks about like contract law and how we should apply it in the case of plea agreements. So we're getting into some cases that deal with agreements, policies, rules, standards. So far, the government has offered no colorable explanation why a defendant's prospective waiver of his statutory right to appeal his sentence should be treated differently than the above examples. The government stresses that a criminal defendant may always choose not to appeal his sentence. And that's what the government argued in their brief. But a litigant may also choose not to exercise his right to remove an existing case to federal court or bring suit to vindicate a Title VII or antitrust injury. And none of that has prevented us from calling prospective waivers void in those contexts. So even if someone doesn't raise it, we could still call something waived. The government, not waived, void. The government also contends that prospectively waiving the right to appeal a sentence does not implicate broader social interests that form part of an unalterable statutory policy. But it's hard to see on what basis we might conclude that the Sentencing Reform Act's promise to defendants that they may appeal their sentences implicates social interests in statutory policy any less worthy of respect than similar promises found in so many other statutory regimes where we've said prospective waivers are impermissible. Certainly, one would think a criminal defendant's right to appeal his sentence ranks at least as highly as, for instance, a right to nullify a contractual provision, relieving a carrier from liability for damage to the goods it transmits. So if we can waive like liability to damage for packages, but we tell someone who's might be losing their liberty in the criminal justice context, you've got no pathway to relief, no way to appeal. Is that kind of ridiculous? Or is it right? Do we want it to be one and done? If a defendant may prospectively waive the right to appeal his sentence, too, one might wonder what's to stop prosecutors from pushing their luck further yet. Might we eventually face plea agreements that include prospective waivers of the defendant's right to complain about future unreasonable searches and seizures of his home? Now, remember, a lot of, like really every, you give up your right against searches and seizures. If you're on probation, you're consenting. It's just part of the terms. You could be searched. Some agreements explicitly spell out that, like, we can come and look at your phone, what you're doing in your phone. If your probation officer wants to come out there, look at your house, look at what's going on in your phone, they'll spell the specifics out. You do not have that same Fourth Amendment right after you've been convicted and you're given certain sentencing conditions. So Gorsuch is like, hey, we've got some considerations here. If we have this conveyor belt of plea deals, now we have a conveyor belt of like a permanent free pass for someone to not have their Fourth Amendment right as they normally would, but for this plea deal that maybe they wouldn't take if the plea deal system worked differently, right? So it's the influx of plea deals, which means an influx of convictions, is leading to an influx of people essentially kind of voluntarily giving up their Fourth Amendment right. So they say, might we eventually face plea agreements that include prospective waivers of the defendant's right to complain about future unreasonable searches and seizures of his home? And they cite here, L. Gill, Virginia governor, vetoes a ban on plea deals that waive people's constitutional rights. It's from Bolts. It's from April of this year. And let me get rid of the highlighter. Let me see if I can just copy. Oh, it's clickable. Let me let that load. Dropping that in the chat. I'm just going to call it the Bolts article. All right, so what happened? Do they describe what happens here? All right, he just cites to it. So let's jump in and take a quick look. So this is from Bolts. Virginia governor vetoes, and I appreciate they got a record of it. They're using a permalink. Virginia governor vetoes a ban on plea deals that waive people's constitutional rights. Abigail Spanberger blocked a bill to bar prosecutors from pressuring Virginians to waive protections against unreasonable police searches as a condition of pleas. April 14th, 2026 by Lauren Gill. This is kind of tiny. Let's do it like this. Virginia Governor Abigail Spanberg on Monday, this is back in April, vetoed a bill that would have prohibited prosecutors from asking people to waive their Fourth Amendment rights against unreasonable searches and plea deals, a practice that disproportionately impacts people of color. Spanberger's rejection of the legislation follows a veto of a similar bill by former Governor Glenn Youngkin, a Republican, in 2024. And I think Spanberger's a Democrat. Oh, they say it in the next sentence. So this is kind of pointing that, like, you know, it's both sides. Both sides are like, nope, we're not doing this. Spanberger, a Democrat who took office in January, said in a statement that these waivers are a common practice in Virginia courtrooms and that restricting them would limit plea bargaining options, or taking away that plea bargaining chip, for defendants and Commonwealth's attorneys as they seek negotiated resolutions. Spanberger's statement, why couldn't they just use that as a term in their plea bargaining? Like, if you're willing to forgo this right, then we'd be willing to consider this. Or, I really want to retain that right, but I'm willing to do this other thing instead as a concession. Like, I don't get how protecting negotiations, how making sure something is always enforceable or always can be included promotes negotiation ability between two parties. But that's just not how I generally view negotiations. It like, to me, it constrains the creative options. So they say that Spanberger's statement closely matched arguments made by the Virginia Association of Commonwealth's Attorneys, the group that lobbies on behalf of prosecutors. Nathan Green, the Commonwealth's attorney for James City County and the city of Williamsburg, defended the practice during legislative hearings on the bill, saying the waivers are useful to prosecutors as bargaining chips during plea deals. Critics say threatening defendants with harsher sentences if they don't sign away their constitutional rights is unfair and leaves them with an impossible choice. It's really sad and unfortunate that this practice is going to continue. Rob Pogenglass, executive director for the criminal justice advocacy group Justice Forward Virginia, told Bolt. He was surprised by Spanberger's veto. It's just really disappointing that racial equity has fallen so low on the priority list. Opponents of the waivers have argued that their use has been racially discriminatory. In 2020, for example, 96% of people living under Fourth Amendment waivers in Richmond were people of color. Dang. Records show 96%. Obtained by criminal justice advocates and shared with Bolt show. Comparatively, the capital city's population was 45% Black and 8% Hispanic. As Bolts reported in 2024, people who agree to a Fourth Amendment waiver give up protections against unreasonable searches and seizures, essentially allowing police to search a person, their home, or a vehicle at random for a specified number of years. Sometimes, and this is really where I think this is what Gorsuch is talking about, sometimes these waivers stretch beyond the completion of parole. So you're done with your time, you're done with your supervision, but yet you still don't have your Fourth Amendment right restored. According to data obtained by Justice Forward Virginia, some people have agreed to waive their rights for as long as 20 years as part of their plea deals. And because a person has waived their rights, they have no legal recourse to challenge anything found by police during a warrantless search. The legislation, Senate Bill 23, would have barred the waivers in all cases except those involving child sex offenses. The bill would also have prohibited prosecutors from asking defendants to waive their rights to later expunge their record or keep it sealed, a practice in some Virginia jurisdictions. All right, and then Pogenglass says we shouldn't be waiving people's constitutional rights. He tells Bolter, explaining why he advocated for the bill. This is the only right where that happens, where people are out in the world and they're missing one of their fundamental rights under the Constitution. In vetoing the bill, Spanberger broke with the rest of her party. All Democratic lawmakers voted in favor of the reform when SB 23 passed the state House and Senate earlier this year. All Republican lawmakers who took part in the vote opposed it. So kind of interesting to see Spanberger, yeah, just breaks with the rest of her party. Democratic leaders lack the supermajority they need to override the veto. Proponents of the legislation said that the waivers permit police to violate the Constitution and protect officers when they engage in misconduct. Ashley Shapiro, a Richmond public defender and board member of Justice Forward Virginia, described how police stop and search people at whim and then use the Fourth Amendment waiver to justify the stop. She says there isn't really a broader public safety goal that's achieved by these. Instead, it's just a degradation of, again, not only the constitutional rights of people who have them, but everyone else as well. Court records reviewed by Bolt show how some local cops have integrated the waivers into their regular policing. One January 2025 legal filing on behalf of a man stopped and searched by police in Harrisonburg, a rural city on the edge of Shenandoah National Park, describes how the state's probation and parole department has provided monthly lists of people with waivers. So it's not just like, oh, we're stopping you because we have a reason, and then we happenstance find out that you have this waiver and you have no right to refuse a search. It's, we have a list. We know who you are. We know who we could go search, and you can't tell us no at any given time. Monthly lists of people with waivers to the Harrisonburg Police Department. According to the legal filing, city police officers regularly make calls to the dispatcher to ask where a particular person is on the list. The man who was searched during his stop because his name was on the list ultimately had his case dismissed after it was revealed that police were relying on an old list when they searched him. So we're not even using current waiver status when we search people. Aaron Cook, a Harrisonburg attorney and president of the Virginia Association of Criminal Defense Lawyers, VACTL, told Bolts that prosecutors have used the waivers in every felony plea deal in the city for more than a decade. Some of his clients have had their waivers extended along with their probation because they were unable to pay court costs. So you're not really doing something, yes, paying your costs is a term of your probation, but you're not doing something criminal. And your rights, your loss of rights is being extended. Should it be that way because you're late and that's the terms? It is what it is? Or should we reconsider that? So then we've got, it was so ingrained that you had to sign it or you didn't get your deal, he said. There's a lot of issues with it. Virginia prosecutors who use the waivers have said they'd end up imposing harsher sentences if they can no longer ask defendants to sign these agreements. If we don't have a substitute to incarceration, we're left with incarceration. So they're saying there's no other negotiating thing that we could do. Taking this out of the prosecutor's toolbox could have what I think is a contrary impact, where what happens instead is instead of agreeing to something below the low end of the guidelines with a Fourth Amendment waiver, we don't have that tool anymore. And then we have Richmond Commonwealth attorney Colette McEachin, yeah, also defended the practice in an interview with Bolts 2 years ago, saying that signing a waiver is a difficult choice that the person has arrived at through their own actions. But use of the waivers among Virginia prosecutors varies, and some don't use them at all. All right, so it's not like this is all the time. Advocates say this shows that prosecutors don't need them. So is it really gonna, you're gonna have nothing in your toolbox left if we take this away? Because clearly deals are being done, negotiations are being done without this tool already. So there are plenty of jurisdictions that don't use these, so it's certainly not integral to crime fighting or integral to clean negotiations. But what it is super coercive, Shapiro said. Spanberger also vetoed other criminal justice reform bills on Monday. This was back in April. One would have allowed judges to defer sentencing in more criminal cases so that people can complete treatment and programs to avoid a prison term. Another would have blocked prosecutors from charging people with felonies for having trace amounts of controlled substances. And then that's the end of this article here from Bolts. Linked in the chat there, if you want to take a look. Also linked in the opinion. And we were here. Where was that? Okay. So this goes on. We talked about Bolts, the Bolts article, and then also, or prospective waivers of a defendant's right to seek a jury rather than a bench trial in future proceedings if he ever is charged with another crime. Is that something that people do in negotiations? I don't know if this is just a pure hypothetical, because that's kind of how we started, right? Because we started with, might we eventually face plea agreements that include prospective waivers of the defendant's right to complain about future unreasonable searches and seizures of his home? But then we deal with something where that seems to actually be happening in some cases, where the extension of this Fourth Amendment waiver is extended to the future beyond supervised release and can be extended if you're not paying your fees. But then we get this, which I'm not sure if this is actually happening or what Justice Gorsuch means here. Maybe he's just like food for thoughting. Like, what if, can you make it a negotiating term to say, hey, if something happens in the future, totally unrelated to this, you get charged with something else, you can't have a jury trial. You give up those 12 orangutans. I don't know. So they cite here, see Hamburger purchasing submission as a footnote. Two of my colleagues seek to bolster the government's defense of prospective appeal waivers, but respectfully, their offerings have problems too. After admitting that some rights cannot be prospectively waived, Justice Barrett, and we didn't read her concurrence, fails to provide any reason why a criminal defendant's right to appeal an unconstitutional or unlawful sentence should not be among them. Meanwhile, Justice Thomas seeks to distinguish between procedural mechanisms, which he says can always be prospectively waived, and substantive rights, which he agrees sometimes cannot. But that distinction cannot explain our cases. Morse involved a procedural right, the right to remove a lawsuit to federal court, yet we held it insusceptible to a prospective waiver. And in Alexander, the plaintiff did not prospectively waive substantive protections against racial discrimination by his employer. Instead, he waived a procedural mechanism to vindicate those protections, agreeing to arbitrate future claims of racial discrimination rather than litigate them. Yet there, too, this court held the prospective waiver void. Given precedents like these, it would seem to follow, fortiori, that a waiver like Mr. Hunter's is also void, as it prospectively deprives a defendant of any forum, whether on direct appeal or through, it's a long footnote, oh my god, it's a long footnote, or through collateral attack, to seek relief from an unconstitutional or unlawful sentence. And they cite Penn Plaza from, holding an agreement to arbitrate ADEA claims, generally enforceable in light of an arbitrator's capacity to resolve discrimination claims brought under the ADEA. But conceding that such an agreement will not be upheld if a party could block arbitration of those claims. And not only is Justice Thomas's account difficult to reconcile with our precedents, under his view, it would seem the government could go so far as to insist that defendants prospectively waive the procedural right to a jury in any future trial against him. So he's like, Thomas, do you really want to make that argument? Because by your logic, that was a long footnote. All right, so we're actually here. We're now here. So we've got, of course, none of these questions is before us in this case. All, however, may warrant exploration in future cases where they are presented, as may others besides. And then the Melancone, where Justice Parker, there was Concurrence, discussing the potential application of the unconstitutional conditions doctrine, and a few other cases here. Case here, United States v. Gordon, that applied contract principles to a plea bargain's terms, and the same for United States v. La Jeunesse. 200 years ago, I'm doing a flashback, it was likely unimaginable that almost every federal criminal case would be resolved by a plea bargain. 40 years ago, it may have been no easier to foresee that plea bargaining defendants would be pressed to waive their statutory right to appeal sentences yet to be imposed. Let alone that the federal government would argue that these waivers prevent defendants from appealing even blatantly unlawful or unconstitutional sentences chosen by an orangutan. This court is not responsible for all these developments, but it has encouraged some of them and stood silent while others took hold. Today, the court finally begins to correct course. Again, this to me is like, these three justices signed on to this concurring opinion are like, bring it. Bring all these other issues dealing with plea bargains forward. We want to hear them. And maybe they wouldn't get enough to do the granting of a writ of certiorari for future cases that want to bring an issue forward. But there's at least three that are like, come on, this is just a start. We want more. They say they're taking an important step towards reining in appeal waivers. It is not a solution to all plea bargaining excesses, and perhaps not even those associated with appeal waivers, but it is a start. So there we go. That was Justice Gorsuch's concurrence. And again, interesting arguments, interesting concerns. I thought it was just so cool to see the initial case law, the quotes of how plea bargains were looked at many years ago. And this idea that now they're used so frequently. The idea that they are the system and not just an adjunct alongside the criminal justice system. I thought it was very, very cool. So guys, we've been at it for 2.5 hours. So I think what I'm going to do is I might just link to the oral arguments. They were heard earlier this year in March. Let's see. Let me get the link. So rather than watch the oral arguments, because I was just going to let them play and wrap this out. But I think if you guys are interested in listening to the oral arguments, I'm just going to link you to them. I started this side channel, just called the Argument Archive. And I did it because there's often times where I want to upload arguments or bring attention to a little tiny Court of Appeals argument that's going on that might not make it to YouTube otherwise, and or have something where there's captions and you can see who's speaking, right? So I did this little thing, and at least for SCOTUS, Oye provides transcripts with the speaker name, so it's pretty easy for me to produce and format this so you guys can see who's speaking at the same time. It might not be something that's possible for tiny little cases where I don't even know who's who, but that way you can watch the transcript and see who's speaking at that time. And it doesn't spill over and like clog up this channel where, hey, if I really only want to watch things where Kat and the chat are live and I can go and hang out with people, and then Kat's just uploading a bunch of archival stuff. I just wanted to separate it. So this is a separate channel that's going to focus on oral arguments. There might be some, like if there's like really good opening or closing arguments in a trial, like legal arguments, anything that's like contentious, maybe it'll make it here as well. But it's just a way for me to kind of keep my channel here with Kat Not Williams more uniform. Right, so I'm going to link to this. So if you want to check out those oral arguments, they're there for you. If you just want to subscribe to that channel and just see what I throw up. The next thing I'm going to do is New York Times v. Sullivan, and not just the main oral arguments. A lot of people don't know that New York Times v. Sullivan, which is, you know, the limited purpose public figure, should it be where we have to argue that to bring a defamation case forward, we need to prove actual malice, right? That originates, people cite back to New York Times v. Sullivan. There were actually more than one case that was heard together. There's a companion case to that issue that was part of the ultimate decision in that case, even though it's always referred to as just New York Times v. Sullivan. So I'm about to upload both arguments there, and a lot of people have not heard the second. So I think that's going to be an interesting major one to start with. It was going to be the first major SCOTUS upload on this channel. But then this case decision came down, and I was like, well, let me just put this on there. So that's just a side project, guys. I hope it's something that's useful to you. And, I don't know, stuff will go up there periodically when I have free time to upload interesting cases. I think we'll do that instead of turning this into a 4-hour stream. Yeah. Yeah. Aaron's like, boo, 6-hour stream. The reason I'm saying that, I've been so behind. If you guys didn't know, I went in person to court for a case that's currently underway, approaching a retrial. It's the Rashawn Jones case down in Florida. First case ended in a hung jury and a mistrial. Reports say that the jury was split 5-1 in favor of acquittal. Again, 6-person jury in Florida for a second-degree murder case. Cold case, 15 years cold, where the only change in circumstance is the case file was handed over to a new lead detective who says he saw things with fresh eyes. That's what we've got. And that detective, there's all of these pre-trial, almost side story matters. I don't want to call them side stories because I think they're really relevant, but they're being treated procedurally as side stories, where this lead detective is now being accused of operating a burner account on social media while he was subject to a sequestration order, even while he was a testifying witness, because he testified across more than one day. He was on social media on this burner account making comments about the guilt of the defendant and the credibility of other witnesses and all of these things that you're not supposed to be doing. And now there's this whole side story where the state is accusing the defense of, in trying to look for this after the court wanted supplemental information, hey, go look for more information to establish your basis on why you think this burner account belongs to this lead detective. They go and do that, and now the state's saying that that's criminal activity, that they had no right to look for that information. And the next major issue coming up on July 6th, they want to shut down the courtroom. They're fighting to gag the attorneys, but they're also fighting for exclusion of media access to the court proceedings, right? So major right of access, First Amendment issues coming into play in the Rashawn Jones case in Florida. And that case is eating my time, and rightfully so. I'm very passionate about it. But there's some cases that I'm backlogged on that I haven't been able to talk about. So if we get to end this, I might be able to do another stream today, either on the updates in the Scott Spivey, the road rage case in South Carolina. It's not a criminal case. It's civil actions where we're pursuing for the estate of Scott Spivey wrongful death damages. And it's been a time. So there's been some updates in that case. Want to talk a little bit Lindsay Isaacs, another Florida case, where someone was wrongfully arrested because a lazy law enforcement officer relied on flock cameras, saw a vehicle was on another road kind of nearby an accident around the same time, and was like, all right, cool, that must be the right person. It totally wasn't. and she filed a federal lawsuit about that wrongful arrest. There's just a lot, right? So I think I'll probably do a stream this evening on one of those cases that we're behind on. And one of these days, I can't wait to tell you about what happened with the two prosecutors in the Rashawn Jones case, falsely accusing me and stupidly accusing me, because if they took 2 seconds to investigate their claims, purported claims against me, they would see that it couldn't be true. But they chose not to. And we'll do a stream in the next week or two on what happened there. I think you guys will enjoy that one. So other than that, I hope you guys are doing very well. Very well. Yeah. Mavka says the 5 orangutans voted to acquit Rashawn Jones of the 6. The other orangutan didn't want to participate in deliberations. So, thank you for subscribing to the new channel again. It's going to be a hobby project, you guys. And again, there's not all videos are going to be made with like the production where the transcript's live on the screen, and but I will try to always include in the description a link to the docket, the important briefs, or the opinion. Some uploads might be before an opinion comes out, but I think a lot of that channel will be here's all of the meat and potatoes, or I can go back and update and add the opinion whenever it drops. But hopefully, if you guys like listening, I actually really love the audio quality of the recordings from the Supreme Court. I just really love the way it sounds. So it's like almost peaceful to like listen to Supreme Court arguments. It's very calming just because of the auditory, like the timbre of people's voices. It just has something different to it as it comes through on the recording. So I don't know. Sometimes I just like to listen to that in the background. If you're like me, I hope you enjoy it. And then yes, Factual Lie says, I'm waiting for your stream on the gag order. Man, I can't wait. I don't want to go live and just have a stream where I'm talking about 2 idiots. And if you guys are such idiots about something that's verifiably untrue and you could have figured it out in 2 seconds, why should I trust your representations and your theory of a prosecution against somebody if you can't see the obvious? If you can't see the obvious. But I'm going to try to be more academic than that when I gather myself and do a stream on that. So yeah, I was accused. I was falsely accused. And the defense attorney tried to offer a correction that was correct. And both prosecutors tag teamed because the defense attorney pointed out, was like, could it have been law and crime? And prosecutor Kristen Rodriguez was like, no, it wasn't. And then Christina Diamond was like, it had to be Kat, not Williams. We don't know how she did it. And I think, quite frankly, their dumbasses don't even realize I was sitting in present in court that day. And they were accusing me of recording the Zoom feed on my laptop. And you could see me in court. I do not have a laptop. So, but they insisted. So why should I trust anything else they represent to the court? Yeah, and there's way more to it. There was an ESPN attorney in the courtroom at the hearing where they accused me, who said that they wanted to file to fight any potential exclusions. So I do think that this hearing on July 6th, which I plan to go in person for, maybe not, but I have concerns that they're not even though the restriction isn't going to formally be in place, I feel like it will already be restricted. Right? So I feel like I should go in person, because who knows if we'll be able to see what happens otherwise. And I encourage, this is a Miami case. So if you live close and you're interested, this is at the Richard Gerstein Justice Building, July 6th. Pay attention to this case, because they're trying to cut the media out of it. They're trying to cut public access. And maybe the judge won't ultimately order that. I don't know. Maybe she'll gag the attorneys and not exclude the media. I don't know. But if the media is excluded, the coverage by ESPN, the coverage by Law and Crime, the coverage of local outlets like NBC6 and Local 10 will go out the window. But I do expect, and Miami Herald, I do expect that the press outlets are going to be fighting and filing notices on this matter as well. So I think it's going to be a bigger deal than really anything else that's happened at these pretrial hearings. So yeah, really, Christina. Yeah, Kristen Rodriguez and Christina Diamond. The judge is Christina Miranda. It's like confusing to get the names straight. But yeah, so yeah, we'll see. We'll do a whole. Oh yeah, and also the judge took issue with me. She's like, it's funny, these websites following the accusation about me. It's funny, these websites, things that I don't even know of. somehow they're talking about, as if the implication should be something's being leaked to me, when that's not true either. You want to know what her example was? I read a habeas petition that's publicly available on the 3rd District Court of Appeals, like docket where you can search for cases. That's where I accessed it. That's what I read from. I feel like I often pull the dockets up on the screen. Like, this is not a channel where I do, like, I'm not really like a scoop or like, here's what a source just told me. It's not really what I do. I look at documents, I look at filings. Like, that is my interest. That's usually what this channel is about. Of course, sometimes in the chat, like, we get to discussing, like, somebody said such and such, but it's not the purpose. It's not my priority. It's not something I seek out. So it was just so weird that the judge seemed to be miffed that somebody was out there reading this thing that she didn't even hear about. And she started talking about how part of what she was concerned about and needed to find a solution to was the inaccuracies and the conclusions being made out there. So not her basis for wanting to put some restrictions out there to the access is not in the interest of justice or preserving the integrity of the court. She did state those reasons at the end of the hearing, but her grievance was that she didn't like the inaccuracies or the conclusions being made out there. And I don't think that's an appropriate basis for excluding public access and these restrictions. I think it's disgusting, quite frankly. So I've got a lot to say on that. And I'm glad I got to get a little bit off because I've just been kind of sweltering on it. But thank you for joining me for this discussion on what happened with this opinion in Hunter v. United States. I will opine more. I am a big fan of the First Amendment. I don't know, but I suspect that the defendant in the case that I'm griping about right now might actually want public access to the trial. I have no reason to believe that the defense is seeking public restrictions. So to me, it doesn't make sense that an argument could be made by the judge that, oh, I'm doing this to make sure the defendant gets a fair trial, because the defendant has a right to a fair trial. I haven't seen a waiver of that right. Going back to waivers. It's just a lot going on. There's a lot that I don't think is right in this courtroom. So let's go. We'll talk about that on another stream. That's a little bit. Oh yeah, you want me to do a Conspiracy Friday stream? Start that up. But yeah. So I hope you guys pay attention to that case as it approaches a retrial. It's slated for September 14th. Maybe it won't stick to that if all these issues keep going. But it's a wild case for a lot of reasons, and it seems like the reasons the case are wild keep getting more and more wild. So thank you so much for joining. Thank you so much for everyone that shared their thoughts on what we were talking about, and this nice encouragement at the end on what's kind of become a case I'm part of a side story again now. I'm in it. And we'll see. Yeah, did my face drop to the floor when she read your name? So I was listening to this hearing where I was mentioned while I was streaming the George Pino trial with Bob and Allie. And at some point on that stream, you'll see me like turn off my camera because I was just like sitting there like, and I knew my face wouldn't stay normal on that live stream where I'm collaborating with Defense Diaries. You can see me jump off at some point in the morning. When was the hearing? The Wednesday. So whatever day Wednesday was in the George Pino trial, if you watch the beginning-ish of that stream, that hearing started around 10:30 Eastern time. So we were probably like 30 minutes into... Actually, I don't think they called Rashawn Jones' case until like 11 something. So we were probably about an hour into the George Pino stream when the hearing got underway. It was only like 20 minutes long. And I heard cat. And I heard K-A-T-T. And I'm like, oh, what? What is happening? What is going on over there? So, yes. My face did drop in a way, although I got off screen to react to it in my own bubble. So, looking forward to you guys. Thank you for joining. Have a great weekend. And maybe see you later today. Maybe see you this weekend. Maybe see you Monday. You never know. Bye, guys.